Unmuted. Banking and Trust by Moving Titles in Commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Welcome, everyone, to this Monday, October 11th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and tonight's Monday, the Trust Ambassador call. So we'll invite the Trust Ambassadors on to give their rendition for tonight.
Unmuted.
You on, Eric? I think you're unmuted now, so try.
There it is. Hello, everyone. This is Eric.
Hi, Eric.
And are we going to have some of the other TAs participate tonight? If so, if the other TAs are on, please state your name and say hello to everyone.
Floyd's on.
Hey, Terry's here.
Downtown Texas. Mike's here.
Sounds like that's about everybody. What I did is Christian was asking me about sharing with everyone about how to do a bill in equity. But I started thinking about the logical steps in order for us to do that. And I started thinking about, in order for us to do that bill in equity, we still have to know how to create that jurisdiction in the court in order to bring our bill in so it can be under special jurisdiction or our jurisdiction. So I went into CJS because I recently got a set of them, everybody. And I was looking in the Volume 21 on courts. And in Volume 21 in courts, there's it begins in, I believe, Section 80 of Volume 21. And the area of is J, necessity of showing jurisdiction by record. And if anybody's been with NTT for any period of time, they know, or y'all know, that we have to have two records to make something a fact. So when I saw necessity of showing jurisdiction by record, I thought to myself, this is consistent with what NTT is. And we have some sections in here under Section 81, courts of inferior, limited, or special jurisdiction, which I thought might apply to us that we can have some discussion about. And there's a couple others. I'm just flipping around here. We have exercise of special statutory powers. So one of the key words that I look for is special or particular or peculiar. Section 75 is courts of inferior, limited, or special jurisdiction, which I thought might provide for some especially interesting conversation. that we might be able to lay the foundation for when we bring our bill in equity in order to make sure that we understand how to create that jurisdiction so we can be that 900-pound gorilla, as Christian has talked about. So under actually Section H, or Chapter H, or I don't know how you call that in CJS, but under presumptions as to jurisdiction, under 75 of Courts of Inferior, Limited, or Special Jurisdiction, that's where I want to start to read and to have some discussion, because I thought this might be something of a special interest to everybody that might help us have the foundation so we know how to bring our bill in. And it starts out with, while no presumption exists in favor of the jurisdiction of courts or other tribunals or inferior, limited, or special jurisdiction, once jurisdiction is established, the regularity of their proceedings and validity of subsequent proceedings are presumed. There is no presumption in favor of the jurisdiction of courts of inferior, limited, or special jurisdiction, or in favor of the jurisdiction of inferior magistrates or tribunals exercising judicial functions. Jurisdictions in such cases must affirmatively appear, and the fact conferring jurisdiction must be affirmatively found to exist. However, it is within the constitutional power of the legislature to change this rule. And that's precisely why one of the books we're looking at very closely is post-1912, because the Supreme Court changed quite a bit about equity. That's why we're looking at Equity Procedures by Carlin, that was printed in or published in 1921. And then this reading on, but this section goes on to say, mere exercise of jurisdiction by such courts does not raise a presumption of the existence of the requisite jurisdictional facts. One who relies on a decision or order of such court, or who claims any right or benefit under its proceedings, must affirmatively show its jurisdiction by alleging and proving it. This rule applies to jurisdiction both of the person and of the subject matter. Where, however, jurisdiction is once established and these courts have not transcended their powers, the validity of subsequent proceedings will be presumed until the contrary is shown. And the same presumptions of regularity will attend the proceedings as apply to the acts of courts of general jurisdiction. One who relies on a loss of jurisdiction to invalidate a judgment must affirmatively show such a loss. Now, if the other TAs would like to have some discussion about this section, I think this would apply. If anybody has any comments or any questions about it, please step in now and say something.
Well, when you're talking about jurisdiction, Eric, we just have to determine if that court has the ability to hear a case in equity, don't we?
Actually, Floyd, that is one of the parts. But the other thing that this section pointed out was that you have to have the facts. And two witnesses make something a fact. And we have to affirmatively put that in the pleading. So if we're going to do a bill in equity, Floyd, I can hear you typing.
Yeah.
If we're going to do a bill in equity within the four corners of that pleading, of that bill, we have to make sure. Hey, I don't know who's got all the background noise going on, but it's awful loud.
Well, I just set my computer down. I have to get something.
All right. Well, if you're going to do that, mute out. So if we're going to put that in the bill, we have to affirmatively show the facts, or point to the facts, so we can go ahead and show that we have jurisdiction in private equity. And that's exactly why I wanted to bring this out. But once that's established, the other thing I wanted to point out is once it's clearly established, it is presumed that all the subsequent proceedings after that are presumed. So this is key to start out on as far as foundation, to make sure that that's where we begin and that's where we head to. Now, courts of limited or special jurisdiction is Section 79, okay? Recital of jurisdictional facts in the record of a court of limited or special jurisdiction is conclusive unless want of jurisdiction appears on the face of the record. Where the record of a court or limited or special jurisdiction declares the ascertainment of the jurisdictional facts which appears to be made in the exercise of its authority, it is conclusive unless the want of jurisdiction is apparent on the face of the record of the proceedings. This is true at least where the question of jurisdiction is involved in the question, where it is the gist of the suit, so that it cannot be decided without going into the merits of the case. So that's why it's key that we have our records done properly, and we keep what needs to be private, and we go ahead and do our NOI and SOI in the public properly, and we do our NOI and our SOI in the private properly, so everything doesn't get, so there's no commingling going on. Reading on, it says, on the other hand, where jurisdiction depends upon some collateral fact, which can be decided without going into the case on its merits, the recital thereof, although constituting prima facie evidence of jurisdiction, may be questioned collaterally and disapproved. The prima facie evidence of jurisdiction would be our records in the public, pointing to the records in the private. So as long as we get our records right, even though it may be questioned collaterally and disapproved, as long as we have it properly done, once we get into the private, there will be no disapprovement of the records. And also, this is a key point, a clerical error in the recital of jurisdictional facts is not fatal, so we can always go back if we learn our court rules in order to establish private equity jurisdiction. Necessity of showing jurisdiction by record. Generally, it is not necessary that the record of the proceedings of a court of general jurisdiction should affirmatively show the existence of jurisdiction. Nevertheless, it is required that it appear from the record that the particular cause of action comes with the class of cases embraced with general or ordinary jurisdiction of the court. It is required that the record show jurisdiction over the res, over the person of a non-resident, or over foreign corporations, or conformity to the requirements of substituted service or of service by publication. Under some authority, it is required that the record show jurisdiction to render judgment by default. However, under other authority, the doctrine that the facts or proof thereof upon which jurisdiction depends need not be shown upon the face of the record applies equally to cases of default. It has also been held that where a direct attack is made on jurisdiction, there is no proof of facts on which jurisdiction rests. The intendment in favor of jurisdiction must be supported by the record. Again, they can see records. That's exactly what we got to have. We got to make sure we do this properly before we can even think about doing a bill in equity. So going back to all the previous recordings, we talked about it over and over and over about how to do our records properly, both in the public and the private. Exercise of special powers is the next paragraph and subsection under Section 80, Courts of General Jurisdiction in Book 21 CJS. Where a statute confers upon a court of general jurisdiction special authority not belonging to it as such court, and not be exercised according to course of common law, sufficient matter must appear of record or on the face of the proceedings to show the case to be within such special jurisdiction, since the court is regarded in this respect as one of limited or special jurisdiction. And then Section 81 that I mentioned earlier is well, before I go there, actually summary proceedings is the last paragraph and subsection within 80, is everything necessary to give the court jurisdiction in summary proceedings should appear on the face of the record. Courts of inferior, Section 81 is courts of inferior, limited, or special jurisdiction. It is usually necessary that the record of a court of inferior, limited, or special jurisdiction affirmatively show that the court had jurisdiction. Now, before I read on, TAs, is there anything you want to discuss about anything from courts of general or exercise of special powers that you guys might want to talk about and bring out that you might be thinking about?
Yeah, I was thinking, Eric, that first of all, you mentioned that the courts only have, if I recall, the courts only have jurisdiction over res, and res is property, correct?
Property is one way to term the word res. Res is a thing. I guess it depends on the context you want to use.
Okay, we're talking here in CJS. We're talking the black or the private side. We're talking the public, right?
Well, that's generally the frame that CJS is written, but again, they have courts of general and exercise of special power, and then the next section is courts of inferior, limited, or special jurisdiction. So we have general and special. So you have both the black and the white, Floyd. So it just depends on the context you're talking about.
Well, actually, when we're talking private and public in the public, that's different than what we're talking about in equity. As far as the way we look at equity, that's the only thing I'm trying to clear up here, Eric. Because when I know that when back before 1912, when the courts had equity and at law, basically they had that separated. Today they put that all together, and that's the problem that we're having, getting that separated. Correct?
Well, I think it depends on whether or not you're talking about in the frame of NTT or if you're talking about in the frame of CJS. In the frame of NTT, we clearly understand the distinct difference between special and general.
Well, it was only until NTT came along that we were always having a problem with jurisdiction and getting jurisdiction recognized in debtor-creditor, and you could never get equity in debtor-creditor because you were never dealing in the proper venue. But now that we understand where our equity lies and how we get in there, now we see the difference between how at law and in camera works or equity works. And the only thing I was going to say is that when we're dealing in courts of record, the reason that we have to deal in courts of record, or want to make sure that we're dealing with courts of record, is because that's exactly what we need to show where we are in our proceedings. And that's one of the things that we want to make sure when we go into is that we are in a court of record. That's the point that I wanted to bring out, was because if we're using the court of record to get into equity, that's really what we're using the court of record for. Is to we're only using enough of the at law side to get into the equity side, and it's important to have the record clearly show that we have the proper venue to get into that equity side. So that's the reason that I think that we're stressing courts of record at this point.
And to follow up with what you said, that's consistent with what you were just talking about, Floyd. Again, I'll read this part of this Section 80 of CJS. It says, it is required that the records show jurisdiction over the res.
Exactly.
Okay? Over the person of a non-resident, or over foreign corporations, or conformity to the requirements of substituted service, or of service by publication. If you guys think back to what we've looked at, service by publication was in that document, that old document where you could put you could post it in the paper. You guys remember that?
Oh, yeah.
Create the record.
Mm-hmm. Yeah.
And then I don't know what it means of conformity to the requirements of substituted service. I don't know what that means. Maybe one of the other TAs knows what that means. Maybe if you want to look up that in Black's, Terry, and see if it's substituted services in there and let us know what that means. But just so we know how to create these different records, this is key. So when we go in, we have the records, because two records make something a fact. Two witnesses, two records make something a fact. So then that way, that's what shows the jurisdiction. So when we do bring our bill in equity in, we actually have what we need in order to be able to put that bill in order to go into the private.
Okay, I just wanted to make a point, Eric, that even though it says that they have jurisdiction over the res, that it's important for us to understand they do not have jurisdiction over the equity. And that's because the real man is the equity, and they may have jurisdiction on the at-law side, but they don't have jurisdiction in the equity side.
You're talking about private equity, Floyd.
Yes.
Okay.
And that's why it's important for us to understand how we use the at-law side to get into equity, and why it's important for us to go into a court of law, into a court of record, so that we can get into the equity side.
Hey, Eric.
Yes, Mike.
Well, say we go ahead and we express the trust and everything else, and say that they're a hypothetical, that there is the trustee that you're appointing is a clerk of the trust. The clerk of the court, and that individual doesn't want to be a trustee, but doesn't realize that by all he has to do is say he doesn't want to be a trustee, in return the trustee, but instead that individual does an end run, and because it has the ability to make certain judgment or not judgment, but be able to create defaults or whatever the case may be in any cases, that individual says through an order that they are striking from the record on the UCC side the expression of the trust and also the notices on the county side. Do you think that individual could still get away with doing that?
We've been over. What you're saying is that if a person were to tell the clerk that they are a trustee because they're holding res, and they didn't give the res back, which is what's going on in most cases, and they wanted to do, for example, something that would be inappropriate and strike things from the record in order to keep the record from being created in the public. Is that what you're getting at, Mike?
Yep.
Okay. Well, we do have alternatives for creating the other witness. If we have trouble with the local county that we're in, for example, we can set up a miscellaneous file in federal court and create that other witness.
Well, if those records have already been created, though, Eric, and they strike them from the public, that's fraud.
I understand that, but that's a heightened pleading, and I guess we got to choose our battles here to begin with. So just it depends on what kind of things you guys want to get into. What is it you're in this situation you described, Mike? Are you thinking that we might want to compel performance in the private by the trustee in order to acknowledge and show record?
Well, first of all, I'd probably more than likely repudiate what the trustee is trying to do in regards to an order. But the bottom line is that the trustee is still holding the original trust res, and no matter if that individual tries to extinguish our notices or not is irrelevant because he's holding the trust res.
I understand that, but we're still going to have to create the two witnesses to make something a fact in order to bring that prima facie case. So whether we do it in your local county court, for example, the clerk of the county court is suppressing records or altering records or whatever, whether we do it there or somewhere else, we're still going to have to create the two witnesses in order to bring the prima facie case so we can in our bill in equity. Christian had asked us about talking equity, but what I was doing is I was just talking about the type of things it takes in order for us to grab hold of the jurisdiction. Delivery of legal documents required to be served personally by leaving the documents with an adult resident of the home of the person to be served, with an employee with management duties of the office of an individual, with such an employee at corporate headquarters with a designated agent for the acceptance of service, often with the name and address filed with the state's Secretary of State, or in some cases, like a notice to quit the premises by posting in a prominent place, followed by mailing copies by certified mail to the person to be served. Such service is considered constructive delivery. So to create those records, if we were to do it by conformity to requirements of substituted service, that would be another method of that notice in the public to make that notified. So that's what we were talking about as far as foundationally. Then we gotta have that in order to get to that point where we have a bill in equity. Marshall, is what I was getting at. And then I read a section, exercise of special powers, where a statute confers upon a court of general jurisdiction special authority not belonging to it as such court, and not be exercised according to the course of common law. Sufficient matter must appear of record or on the face of the proceedings to show the case to be within such special jurisdiction, since the court is regarded in this respect to have one of limited or special jurisdiction. So within the four corners of our bill in equity, Marshall, that's one of the things that I wanted to make sure that people are including within their bill.
Okay.
All right? Because if we're forgetting that, then we're not going to get anywhere. We got to show that we have jurisdiction by record.
It sounded like from what you were reading various ways that the courts would take jurisdiction over a matter.
Right.
Can I make a comment?
Who is that?
Darren.
What's your comment, Darren?
Is where the gentleman before was talking about a court of record. Typically, a court of record has four characteristics, and they also may have a fifth. In a court of record, it is the sovereign that decrees the law in that court. Some of the characteristics is A, judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, because it's the sovereign that decrees it in a court of record. Also, 2, proceedings according to the course of common law. 3, it acts and judicial proceedings are enrolled or recorded for a memory and testimony. It also has the power to fine or imprison for contempt. And the 5th one is generally possesses a seal. But the thing is that I'm confusing what the gentleman was saying before is in a court of record that has to be contained within your pleading. But are you taking that into a public forum, or are you still trying to go in on the private side? Because you can still have a court of record even on the public side. But that's what a court of record is.
Well, you said you had a comment. Did you have a comment or a question?
I just made a comment on what a court of record is.
Okay.
There are four characteristics. They also may contain a fifth. And that's what I'm saying. In a court of record, it's the sovereign that decrees the law. So if you're acting as the sovereign in a court of record, you're decreeing it. The magistrate or judge is basically serving as the referee.
Darren, we're not sovereigns. We're grantors. Okay. So we're not talking about sovereigns here. This is a private equity situation, and this is by the law of the grantor, by the person who granted or gave the res. And the court of records on the public side, and the records will point to what we're going to do on the private side. So we don't need to get deep into the court of record, because really what we're trying to do is just make sure we understand that the records exist in order to do our bill of equity, so we can have our jurisdiction, our private equity jurisdiction. Okay? Just to make sure that we know where we're at and how to get there. That's the most important thing. Marshall, did you have anything you wanted to add on Section 80?
Excuse me. You kind of went through it a little fast. I didn't get a chance to absorb all of it just from what I had said to you. It sounded as if it was outlining and naming various ways for the courts to take jurisdiction over the matter. Now, back to the matter of the courts having jurisdiction over the res. Can you read that part again?
It is required that the records show jurisdiction over the res. I'm going to say that again. It is required that the record show jurisdiction over the res. So our records will show jurisdiction over our res.
Okay, that was the clarification that I wanted to give to myself. Our records, because when I first heard it, it was sounding like something different. That's why I asked you to read it over.
Right. Okay, and also it is required the records show jurisdiction over the person of a non-resident, over a foreign corporation, or conformity to the requirements of substituted service, or of service by publication. So just to make sure that when
we're stating that our records need to show this jurisdiction.
That's exactly. Remember, we got to look at CJS as we're looking at it in the mirror. So even though it says the record, Well, the record is the records that we create as grantors. That's the point that I'm really trying to emphasize here. So when we're going into a court of equity, our records show that we have the right and the record to go in there. Going back to page I of Gilbert's, that is one of the key foundational things. So reading on section 81, courts of inferior, limited, or special jurisdiction, it is usually necessary that the record of a court of inferior, limited, or special jurisdiction affirmatively show that the court has jurisdiction. Now, Marshall, this is where you're really going to come in and help clarify things because you're pretty familiar with that Common Laws and Pleadings book. Now, within a bill of equity, are we doing affirmations or affirmative statements within our pleading?
Well, according from what I was reading, it would make sense to.
Okay.
It would actually, it would add more, how should I say, substance to our pleadings.
Well, then it sounds like Section 81 is completely consistent with what the Common Forms and Pleadings book is talking about. Since there is no presumption in favor of the jurisdiction of a court or tribunal of inferior, limited, or special jurisdiction, it is usually necessary, unless otherwise provided by statute, in order to sustain the proceedings of such a court, that the record affirmatively show that the court had jurisdiction. That is held to apply both to subject matter and to parties. The jurisdictional facts required to appear of record are the ultimate rather than the evidentiary facts.
Those will be part of the chief facts that the Bill in Equity book was probably talking about also. That it might tie in there.
They need not appear in any particular form or language.
Well, jurisdiction is definitely key, so it would have to be something of utmost importance to be stated on the face of our bills. So it makes sense.
It is held that if the jurisdictional facts actually existed, a failure of the record to recite or to establish such facts may be supplied by proof aliunde, A-L-I-U-N-D-E. Maybe somebody can supply me the definition.
I'm on it.
Okay. Although in some cases this is denied. The word is A-L-I-U-N-D-E.
A-L-I-U-N-D-E. Aliunde, I believe, but it's Latin, from another source, from elsewhere, from outside.
So
and it says evidence aliunde, if that's the correct pronunciation. Evidence from outside, from another source. In certain cases, a written instrument may be explained by evidence aliunde, that is, by evidence drawn from sources exterior to the instrument itself. The testimony of a witness to conversations, admissions, or preliminary negotiations.
So to share what proof aliunde means in this context, I'll read the sentence again. It has been held that if the jurisdictional facts actually existed, a failure of the record to recite or to establish such facts may be supplied by basically an external source, although in some cases this is denied. And then we have special statutory proceedings, jurisdiction over special statutory proceedings exercised in derogation of or not according to the course of common law must appear. Of course, we're not in common law; we're in private equity. But I just wanted to point that out to so maybe if somebody draws something from the black, to be able to see the white that much better. That's, I'm pretty sure, the...
Wait a minute, before you move on, Eric, I just want to make sure there's something clear in my head. Was it speaking of the courts allowing evidence in from an outside source?
I'll read the sentence again.
Okay.
It's been held that if the jurisdictional facts actually existed, a failure of the record to recite or to establish such facts may be supplied by proof aliunde, although in some cases this is denied.
Okay. So it in some cases, this external evidence to prove this jurisdiction may in certain chances be admissible, and in certain places it would be inadmissible. That's what I gather from that.
Well, a failure of the record to recite or to establish facts may be supplied by proof aliunde, although in some cases this is denied. So we'd have to look up the case site which is Smith versus Klossmer, 35 NE 904 136 IND 105, would be the case site that came from.
Okay.
So that's how we would determine what type of cases that would be denied within. So this is what I wanted to share out of CJS as far as special, to make sure that everybody knows that they got to have the right records before we could really go on to talk about a bill in equity, so we know what's within the four corners of the bill. And so we do it affirmatively, and so we use the bill to point to the records that do prove the private facts that we do have jurisdiction, that we have withdrawn and made a special deposit. So with that foundation, I felt that that's where you could come in next, Marshall, and talk about the common forms and pleadings, or if you want to talk about equity procedures, whatever you feel more comfortable that you know better. That's what I wanted to use to lead into what maybe you were going to talk about, Marshall.
Well, to tell you the truth, I got into the book earlier today from Carlin, and for some reason, everything just led me towards the injunctions section. And that's kind of actually what I was hold on, I'm trying to find, hold on one second.
That was the book you and I were talking about, right, Marshall?
Yeah, exactly. That was the one, because you said go through the table of contents. It's the Equity Procedure book by Leo Carlin. 2 volumes, right. Volume 1, 1921. And there's a lot of great stuff in here, but I don't know, for some reason, the injunction section kind of caught my eye, and I was reading through the injunction section, and it was basically laying out some of the foundations that are needed in order for us to put in our injunctions, and it was definitely talking a lot about notice and when notice is necessary as far as an injunction is concerned and when it is not necessary. And at first, well, in page 990, section 727, it says, by what judge or court an injunction may be awarded. So it said, it is provided by statute that every judge of a circuit court shall have a general jurisdiction in awarding injunctions. Is this too far away from what you was talking about, Eric? Can I continue with this?
Sure. If not, then we'll revert back to some of this other stuff where we can continue to construct the bill. But this might give us one of the key points that we need in order to construct the bill.
Okay. So all right. So tonight we're all about constructing the bill. Okay.
But we're going to be grabbing stuff from everywhere in order to do that.
I want to interject here.
Sure, Mike.
To go back to the notices, and this is very, very important, it's very important that you get certified copies of all your notices. Because what if, like I said in that scenario earlier, that they come in and they try, if the person that you're going after that is a trustee, that is a clerk of the court, is trying to strike the records of them being an appointed trustee, if you have certified copies, guess what? They're in the record. And no matter if that clerk gets them striked or not, they're in the record because you have certified copies of it.
That's a very important thing to bring up, Mike.
But isn't there a certain way to have it put into the record for I guess, a particular case?
Well, let's say, for instance, this is a hypothetical case of someone that I know what's going on right now, but I'm using a hypothetical, is that they appointed a trustee to extend the case. And the trustee is now trying to strike the record at the county level and also on the UCCs. But if you got certified copies of everything, it doesn't make any difference what that individual is trying to do, because first of all, a trustee cannot overstep its boundaries in regards to the grantor settler. It doesn't have that authority. They have to do what the indenture says.
Absolutely.
So I just wanted to make it a point that when you get these notices done at the county level and the UCCs, you have to get them certified copies. That way, those are your Achilles heel. They're your gold sitting there in your pocket. And there's nothing they can do to try to strike them. because now we're getting the courts, we're running into problems with the courts trying to do this now. So protect yourselves in getting certified copies. But that's all I wanted to say to everybody, but go ahead.
Marshall, if you want to keep talking about the injunctions, that'd be fine. Maybe we'll derive something out of that that'll help us for our bill.
Okay, well.
And if you want to announce the book and the page and the section for everyone again, because you said it kind of quickly, that'll help everybody.
This was, hold on, let me go back.
Give the whole title to the book.
It's called Equity Procedures, embodying the principles of pleading and practice applicable to courts of equity and containing many precedents of general practical utility. But the main name of the book is called Equity Procedure, and it's by Leo Carlin. It's 2 volumes. I'm reading out of volume 1, and the publishing date is 1921. And like I said, I was just going over a little bit of it today when I had a small break, and it was just talking about, I went to the injunction section for a couple of different reasons, as a matter of fact. But I went to the injunction section, and starting from the beginning, it was speaking of by what judge or court an injunction may be ordered, and says when a circuit court or judge thereof shall refuse to award an injunction, a copy of the proceedings in court and the original papers presented to the judge in vacation may, with his order of refusal, be presented to a judge of the Supreme Court of Appeals who may thereupon award the injunction. And this would be useful in cases where we would have to, if our injunctions were denied for whatever reason, we would be able to appeal to the higher side, the higher jurisdiction of an equitable side of the courts. And another thing it went on to say, upon an appeal from an interlocutory order dissolving an injunction, an appellate court may reinstate the injunction and demand the cause for further pleading. Now, for people who may not know, an interlocutory means provisional or temporary. It's something that's not final, something that you would be able to put it in order for to, I guess, keep a situation at its status quo while you're going through your proceedings until there's some sort of an adjudication. Now, it's also something intervening between the two commencements and the end of a suit, which decides at some point of the matter, but is not a final decision of the whole entire matter, like I said, until there's a complete adjudication. And also, another thing that I was reading here, it says the court having jurisdiction of a bill for an injunction. It also states that a jurisdiction of a bill for an injunction to a judgment shall be in the circuit court of the county in which the judgment is rendered, as to any other matter in the county in which the act or proceeding is to be done or is doing or is apprehended. Now, it goes on to say that to a judge of the Supreme Court who may review and reverse the action of the circuit judge and award the injunction, which injunction so awarded, it is the province of the circuit judge to enforce and restrain any disobedience thereto by attachment or other process. Nor does it matter that the injunction in question is the second or supplemental bill for an injunction, and where the circuit judge refuses to enforce obedience to such injunction so awarded by the judge of a Supreme Court. Now, this is saying basically once granted, the lower courts must uphold the rulings of a higher court as so, even though it was refused at first by the same lower courts. And the reason why I'm talking about this is because just for me personally, like, injunctions are something that I really want to be mindful of, because if you have an equitable right that is being infringed upon or trespassed upon, you have to learn how to stop it. Now, either it would be by an equitable injunction or temporary restraining order, and this would be able to buy people some time and a little bit of relief to be able to focus on some things. You put in an injunction or a temporary restraining order to stop the foreclosure proceedings, and it'll allow you to put in your records and allow you for you to glean more time and information on certain moves that you may need to make. So this is why it was important for me to get into the injunction section first. But this book is jam-packed with a bunch of stuff in here.
Marshall, what page are you on again?
For the book, it says page 944, section 728.
And what page of the PDF is that?
991 on the PDF.
Announce that again so everybody can find that.
991 on the PDF. Section 728 on the actual book itself.
And that's the court having jurisdiction of a bill for an injunction.
Yeah,
Okay.
Now, down in a footnote, it also states, nor does it matter that the injunction in question is second or supplemental bill for an injunction, like I said, and where the circuit judge refuses to enforce obedience to such injunction so awarded by a judge of the Supreme Court, the writ of mandamus will be issued. Now, this was kind of odd to me because, well, I actually ended up figuring it out, but I didn't know that there were situations where you would have a superior court overturn the judgment of a lower court, and when the lower court gets this judgment from the higher court or the superior court, the lower court still does not obey and follow the instructions or the order of the superior court, and this is where it states that a writ of mandamus will be issued. And a mandamus is to be served, which is an order from a superior court to a lower court commanding a specific performance. And I looked mandamus up inside of the Black's Law Dictionary, I think it was fourth, and it stated, which another thing that I didn't know, that is a mandamus is a legal and not equitable remedy. And that's as per Black Fourth. It was just something that kind of flew over my head because we know about the mandamuses and the letter rogatories. It was actually a couple of documents that I was thinking about using at one time, probably 2 months back or so. And I kind of got away from it, but it was funny to hear about what a mandamus actually does when it comes to commanding a specific performance from a superior court to a lower court.
So a mandamus is an order?
Yes. Yes, sir. Yep.
And what do you put at the heading, mandamus?
That's a good question, Mike. I would think so. Notice of mandamus, probably, something along those lines, or I don't know. Because I really didn't get too far into the actual mandamus itself. It just shocked me to find out that an inferior court would openly disobey an order of a superior court, to where the superior court would have to issue a mandamus to the lower court to do their duty or to obey the order that has been given. Have you heard that before?
No.
Because that was the first for me.
Well, what about, okay, when you're going in equity, you do the mandamus on the at-law side?
That's what it's looking like, because it says it's in Black's Fourth. It says a mandamus is a legal, not equitable remedy.
Well, guys, it only makes sense that we would do the mandamus on the at-law side, because in private equity, we're not going to need a mandamus. That's going to be by our order.
But that's what a mandamus is on the public side, I guess.
Right.
Same order.
Right. And then that might be done in a situation, for example, where we go through private equity, and then we order the public side of the court. Remember, we've talked on many occasions how we go through the private in order to order something at law, in order for a first relief in equity, and then go for remedy at law in that order, and that's exactly where the mandamus might come in at that point, but only in that order. So, but at that point, we might not even need it. But we haven't stepped onto a lot of the areas that we hope to in the future, or maybe not need to, because orders are simply followed and there's relief and there's remedy.
Right, right. Also, it was saying here that there are two types of injunctions, it's speaking of. Let me read this to you. For the purpose of determining the court which shall have jurisdiction of a bill of injunction and of ascertaining what shall be the condition of the injunction bond and before what clerk it shall be given, the act in effect classifies injunctions under two heads. Now,
hey, Marshall?
Yes, sir.
Tell us exactly where you're reading so we can read along with you.
Okay, I'm still on PDF page 991 PDF page, actual section 728. I'm down at the bottom in the footnotes.
On the right or the left?
Starting from the left. And
on the left side of on the left column of the footnote.
Yeah, down.
Okay.
Yeah, the last paragraph, left paragraph, footnotes.
Okay, starting with?
For the purpose of determining the court. You got it?
Yeah, please call that out when you're going to do that, because otherwise we're all going crazy trying to catch up.
Okay, my fault. All right. It says here, for the purpose of determining the court which shall have jurisdiction of a bill of injunction and of ascertaining what should be the condition of the injunction bond and before what clerk it shall be given, the act in effect classifies injunctions under two heads. First, injunctions to judgments. Second, other injunctions to independent or collateral acts or proceedings having no relation to judgments which are to be done or are doing or apprehended. Now, it goes on to say, now, once again, you got two classes of injunctions. Injunctions to and for an order / judgment already adjudicated upon, and then you have an injunction to independent or collateral acts or proceedings having no relation to judgments. So, says on the latter class are injunctions to stay waste. Now, to stay means to prevent, to stop something from happening. On the latter class are injunctions to stay waste, to prevent a nuisance, to arrest the sale of improperly about to be made by trustee, to restrain the doing of an unlawful act prejudicial to the complainant, and for which, if done, he would have no adequate compensation in damage, and the numerous other matters having reference to any previous judgment at law. Now, this jurisdiction is assigned to the courts of the county in which the acts are about to be or haven't already been taken place. Now, the next one would be injunctions to judgment. Now, the jurisdiction is to be in the court of the county in which the judgment was actually rendered. So I found that to be very interesting, knowing that there's two classes of injunctions: an injunction to stop an adjudication that has already been made by order of a court, and then you have an injunction that would actually stop the actions or proceedings of something that has no relation to judgments at all. So that again was something that I needed to know.
And one of the things that I just gathered out of this, and I imagine a lot of people on the call might have tuned into, is starting with, of the latter class are injunctions to stay waste. Starting with that part there, to prevent a nuisance, to arrest a sale improperly about to be made by a trustee.
Mm-hmm.
Okay? To restrain the doing of an unlawful act prejudicial to the complainant, and for which, if done, he could have no adequate compensation in damage.
That would definitely be the beneficiary, the complainant. To restrain the doing of an unlawful act prejudicial to the complainant. The complainant is always going to be the beneficial interest, for which, if done, yeah, you're right, he could have no adequate compensation and damage.
Now, that's on the outlaw side, and I just want to make sure we draw the contrast between the black and the white, the black being the outlaw, the white being private equity. And I want to make sure we draw the contrast, because in the white, we apply the principles of equity in the private to stop, to have that injunction ordered so the sale doesn't take place. And I just want to make sure that everybody clearly derives that out of this section that we're reading. So just make sure that that's why we're looking at these two classes of injunctions. I think it's key. I think it's great that you brought this up. Even though it's not one of the four corners of our bill in equity, it's still one of the things that we're going to progress to. And you know, we all look at different things that we tune into, but I think this is to prevent a sale by a trustee is key, because so many people deal with, again, mortgage situations, and that's exactly what having jurisdiction, doing a good bill in equity, doing a notice of interest in order to stop that sale, in order to get that injunction so it doesn't take place once we're in equity and we extinguish the debt. So certainly this is going to help a lot of people knowing this, and then hopefully soon we'll get to putting a really good bill in equity together as well, Marshall.
Yeah, well, definitely. I totally agree. The injunctions are also critical for the fact that this is the relief that we're ordering. This is the relief that we deserve, and this is the need for these injunctions. Now, in our bills in equity, we would be definitely stating the relief in which we are seeking. Now, that relief would come by way of an injunction. So they kind of go hand in hand, if I would like to say so. You understand what I mean?
Yeah, I think you're right. It's kind of like beginning with the end in mind.
Yeah, exactly.
Okay. Thank you. It's a lot to consider, and you know, that's why we're all on here talking, because one person will point out something the other one might not, that will help everybody learn. Because hey, we all learn from one another every day. So don't think so much.
CW wants to know what page you guys are on.
Same page, section 728, page 991 in the PDF. 991 on the PDF.
And 944 of the book.
Yeah, 944 of the book, section 728.
And the footnotes down below.
Now, one of the things that I was one of the things that I was reading of is it's general practice whenever we are putting together our injunctions to go along with our bills in equity, which is going to help us get the relief in which we seek. It's also become apparent that proper notice of your injunction, although it's not required by all courts I've been reading, it is definitely general practice unless you have a special circumstance or an exigent circumstance where you have an equitable right or an irreparable injury. And if you can prove that on the face of your bill, it can even actually go in your bill, and you can have an injunction ordered in your behalf by way of that alone, according to what I was reading. It's somewhere in here. I forgot. I got so many bookmarks in here. I'll find it in a second. But notice is definitely something that is very, very critical as far as putting together our injunctions to go with this bill. But I don't want to get off too far off topic as far as putting the bill together is concerned.
Marcia, you want to open up for a few questions about the material that we've talked about, or you want to keep reading?
We can do a little bit of both.
I mean, but if there's another section you might have reviewed earlier that you want to bring out on the call, please do.
Okay. Another thing that I was looking at is our injunctions, it seems, have to go to the clerk.
Okay, but where are you getting this from?
Hold on, I was just about to tell you. Now I'm on page 994 of the PDF, section 729. 994 of the PDF, section 729, where it states, the clerk to whom the order awarding an injunction must be directed. It says, whenever an order is made awarding an injunction by a judge in vacation or by a court in term time on a bill which has no other object than the procurement of an injunction, or when the order awarding an injunction is allowed by a judge of the Court of Appeals on such bill, such order shall be directed to the clerk of the court in which the judgment shall have been rendered. If it be sought to enjoin a judgment, otherwise to the clerk of the circuit court of the county wherein the act or proceeding is doing or apprehended, and the subsequent proceedings must be had in that county. Now, the first thing that I had to figure out was, why is it talking about a vacation? And I know it's not going to be the vacation that people mainly think of, so I had to go to Blacks. And the definition of vacation is that period of time between the end of one term of court and the beginning of another. Sometimes, any time when court is not in session. Under practice statutes, the intermission between the calls of the equity docket. So, once again, it's stated that when an order is made awarding an injunction by a judge on vacation or by a court in term time on a bill, basically what I get gleaned from this is regularly the injunction will go to the clerk of court, but if there's an enjoinment on your bill, then the bill for the injunction needs to go to the clerk of the county in which the act is proceeding or doing. In other words, the other county. So if you live in one county and you have an enjoining action to include in your bill, then the defendant, where the defendant lives, the county to where the defendant lives, the clerk of that county would get this bill also. That's what I've gleaned from this. I wanted to actually talk to CW about that also, because definitely a couple of questions that I need to ask about that. But from what I read, it seems like that's exactly what it is. You with me there, Eric? Anybody there?
You're still on. Keep going.
Oh, okay. I thought I got dropped. Sorry. How you doing, CW? Eric said he got dropped. He's trying to get back in now. Now, like, which is page 994 still, the manner of applying for an injunction. The usual mode of applying for an injunction is by petition or motion accompanied by bill of complaint duly verified. And in vacation, the application is always made in this way. So here it's stating that a petition in equity practice, an application in writing for an order of the court stating the circumstances upon which it is founded.
Marshall got dropped, and so did Eric. Eric, are you coming in? Liz, can you unmute Eric, please?
Hello?
Yeah, there you are.
Got dropped. I don't know what happened. Okay, where was I?
Hey, guys. Are we still on section 729, Marshall?
Say that again?
Are we still on section 729?
Yeah, I kind of moved on to section, I think 730 it was. Yeah, I moved to section 730, and I didn't even get a chance to finish reading it because I got dropped. Now, continuing on. Well, I kind of feel like taking you guys off topic from what you was talking about earlier, because I did come in kind of late.
Well, what we were talking about earlier was just making sure that we have the records to establish our own private jurisdiction under special records or special jurisdiction. That was just the foundation. So when we do our bill in equity and then we start talking about the type of elements that are going to go into it, that's all that was about.
Okay.
Okay, so anything that we're talking about as far as foundationally in order to get that bill into equity, anything that applies to it is appropriate.
Okay.
Because if we're going for an injunction and we need to put that demand for performance within that bill in equity, and then if we need to include the order for the injunction within, or the affirmative statement within the pleading to have an injunction in the event of non-performance, then this might all apply very well. And, of course, how to apply for it and all these other things. But I don't know if it's in a situation where we're applying for it because,
this was something that I was looking for, of why when we were talking about the bill in equity earlier, like something kind of told me to go to injunctions. But anyway, section 730, I started reading it before, but I got pulled off. Section 730, 994, page 994 on the PDF, page 947 on the actual document itself. It says the manner of applying for an injunction. Again, the manner of applying for an injunction. The usual mode of applying for an injunction is by petition or motion accompanied by bill of complaint, duly verified, and in vacation, the application is always made in this way. The bill sets forth the grounds for the injunction and the special prayer thereof. And if the case in which the injunction is sought be not ready for hearing, it is usual to satisfy the court or the judge of the plaintiff's equity by proper affidavit appended to the bill.
You know, I'm starting to wonder about if the court's on vacation, judge on vacation, could that be the information signifying the time of when we're in private chambers in our private meeting, giving our orders for performance and for injunction and for the court to go into the outlaw side and award damages if need be? Could that be whenever an order is made, a warning and injunction by a judge in vacation? Could that in fact be that?
Well, back to the definition of, let's go back to the definition. It said vacation, Black's Fourth. That period of time between the end of one term of court and the beginning of another. Sometimes, any time when court is not in session. Under practice of statutes is the intermission between the calls of the equity dockets.
Under practice of statutes.
Yeah.
So that's when this is not going to be under practice of statute because this is under special jurisdiction, by special deposit. So this is not going to be under practice of statute. So this, in fact, is going to be when an order is made by a judge in vacation.
Vacating the order. It's when they're vacating the order. To set aside. Vacation.
Oh, see, I didn't put it in that context. Vacates.
That's what vacation is. You're vacating the order, you're in the process of doing a vacation.
So then, what is that period of time between the end of one term of court and the beginning of another? Sometimes, any time when court is not in session. That sounds like
vacation, vacating, setting aside.
They set court aside, is what you're saying, Christian?
No, they're setting aside the motion for the judgment. You're vacating the judgment. You're setting aside the judgment. You're vacationing the judgment.
See, but based on what Marshall said, that it seems like something's missing, doesn't it, Marshall?
Yeah, it's just even with CW saying what he's saying, it's still not all the way clicking for me as of yet.
Because he's saying when they're setting aside or vacating a judgment, but what that definition says is when court's not in session.
Right. And
court
that's
in session. There's already been a judgment and court is done. Now it's going on to the next session because you're doing an appeal and you're going to be going into another session, and you're going to, between times, you're going to be vacating or vacationing.
Oh, okay. That put a little bit more clarity to it. So, vacating the judgment is post-adjudication, is what you're saying, CW? Like, is it in between, the transition in between?
You're getting the judgment vacated. You're setting it aside.
Okay.
You don't agree with it. You're opposing it for whatever reason. Mistake. You're in vacation. Interim between courts.
Okay. Vacation. So, an interim between courts, you're disagreeing with a ruling or an order, and you're appealing it, so that time in between the two, that would be the vacation period.
Motion to decide or motion to vacate. You're trying to vacate the judgment. You're trying to set it aside.
Right. And that would go hand in hand with an appeal, right?
You could appeal it afterwards, or you could go hand in hand with appeal, yeah.
That's what it does sound so. Okay. So back to what it was saying here, Eric. It was saying the usual mode of applying for an injunction is by petition or motion accompanied by a bill of complaint, duly verified. Now, a bill of complaint duly verified, This is I would believe, our affidavit that is to accompany our bill. It says a bill of complaint duly verified. So that would definitely mean our affidavits. And in vacation, the application is always made in this way. So in between the proceedings, like CW was talking about, when you are going to apply for another injunction, it needs to be accompanied. The verified complaint needs to be accompanied by the bill, and this would also give you grounds for and the evidence needed for, say, an appeal.
And this would be applicable in any kind of situation. We've already been through it, and we want to go back and repudiate their repudiation and bring our bill in for any past court proceedings. This would only be for example, from a past court proceeding where there's already been an adjudication. This wouldn't be for example, breach of trust where we're bringing somebody in for performance.
Right.
Just to make sure we clarify the application.
All right, so and at the end it said, it is usual to satisfy the court or the judge of the plaintiff's equity, which is the right, which is what's fair, by proper affidavit appended to the bill. Okay.
Now, special prayer, therefore, that's jumping out at me.
Well, we don't pray for anything. We order.
Well, the thing about it is the word special is before that. So do we need to make sure we draw the clear line between the public equity and the private equity, between special prayer and what we might do in private as grantors?
Well, the word prayer, even with special behind it or in front of it, it just does not seem kingly to me. It doesn't seem like something that a grantor would do, or a king would do. A king wouldn't pray for any type of a relief. He would order it. That's what grantors do. We order, command, and direct, no matter what.
So if that's the case, then we need to make sure that that's in the realm of the black in the outlaw and the public side.
Yeah. To put together that colorable pleading now, maybe then now it would fly, in my opinion. But as far as a private bill, we can't. We're not praying for anything.
But the thing about it is, if we were to put a special prayer in there, then that might indicate.
Eric, you're breaking up real bad, really bad.
All right. How about now?
All right, now you're good.
And if we were to put a special prayer in there, that might be the wrong thing to put in altogether, because that might indicate that we're saying that there is a adequate remedy at law. So that's something we might want to just stay away from altogether.
Period, yeah. And as a matter of fact, if I'm not mistaken, I think the exact word CW used a long time ago is it sounds feudal, if I'm not mistaken.
Well, what we want to do is we want to draw the line in between. The bill sets forth the grounds for the injunction, and that's where we need to put the period on this sentence, the way we're applying NTT, and leave off this and the special prayer therefore.
Uh-huh.
Okay, because we want to make sure we draw the line. We're not doing at law. We're doing what we have to do at law to get into private equity.
Right.
But really everything else within this paragraph, it looks like, applies really well, and we need to keep every other part of it in mind from what I can glean. And if one of the other TAs feel like there's something that they want to talk about or feel like doesn't apply beside and the special prayer therefore, by all means, speak up. Maybe somebody sees something in that paragraph that doesn't apply to how we might want to construct our bill in equity as far as things we want to keep in mind.
Well, I know one thing, not to cut anybody off, that really jumps out at me is it says the petition or motion accompanied by a bill of complaint duly verified. Now, this goes back to our NOIs and our SOIs. Like, we need to have that material evidence, and we need the verification. We need to attest to an injury, and we need to have a properly constructed affidavit to go along with our bill. And that right there is critical, because if you don't have this affidavit with your bill, then you don't have a verified complaint. You don't have a verified complaint, the courts can't take jurisdiction to grant you any relief. So we definitely have to remember that.
Were there other sections in this book, in the area of injunction that jumped out at you, Marshall?
Yeah, notice. It talked a lot about notice, so that's why I kind of stuck with it. Section 731, in the very next section, which is PDF
995?
PDF 995, Section 731, says, as to given notice of the application for an injunction, says whether the application for an injunction be made in term time or in vacation, the court or judge may require that reasonable notice be given to the adverse party or his attorney at law or in fact of the time and place of moving for it, which is your injunction, before the injunction is awarded. If in the opinion of the court or judge it be proper that such notice should be given. And if the application contemplates the appointment of a receiver as well as the awarding of an injunction, notice of the time and place of the application should be given unless the case be so urgent as not to admit of delay. Now, once again, it goes back to, in each state, it varies on whether or not you are to give notice of your intent to put in an injunction. Now, if so, you would have to check your local rules of evidence. But then again, if you know how to properly claim an irreparable injury on the face of your bill, then this obviously wouldn't apply to you, because if there's an equity that needs to be protected, an equitable right, then definitely notice is not necessary, because you have certain situations where actually giving notice would accelerate the injury that could be commenced against you, as a matter of fact. And if you were to look down at the bottom footnotes, same page, 995, it says, bottom left-hand footnote, it says, the court in this case, quoting from High on injunction, says in its opinion, while the usual course is to grant an injunction only upon a bill duly verified, it would seem that the oath of complainant or other persons conversant with the facts may be dispensed with if the confidence of the courts can be otherwise obtained. Now, it's two things. First of all, let's go back to the beginning. It says the court in this case, quoting from High on injunction, says in its opinion, while the usual course is to grant an injunction only upon a bill duly verified. Once again, your bill has to be verified. You have to claim an injury. It would seem that the oath of complainant or other persons conversant. Now, the word conversant means acquainted or being familiar with something. It says, or the other person conversant or familiar with the facts may be dispensed with if the confidence of the court can be otherwise obtained. Now, it was something that was kind of bothering me about the word dispensed with, and I'm glad I looked it up, because I went to Black's Law 4th, and I looked up dispensed, and it says etymologically, dispense means to weigh out, pay out, distribute, regulate, or control. But when used with the word with, it means to do without, or doing away with something, or being synonymous with abolish. And it just so happens that in this same sentence, it used the word dispensed with the word with. Now remember, in the definition it says, but when used with the word with in quotations, W-I-T-H, it means to do without or do away with, and being synonymous with abolish. So going back, it says, this person with the facts may be dispensed with the confidence may be dispensed with if the confidence of the court can be otherwise obtained. Now, I wanted to talk about that just for a quick second because it was kind of sitting in my brain where it says the complainant or other person conversant or familiar with the facts may be dispensed with or done without if the confidence of the court can be otherwise obtained. Now, confidence, that's for me a trust terminology, and my question would be, how can you otherwise obtain the confidence of the courts?
Inequity.
What'd you say, Floyd?
Inequity.
Inequity.
By record proving jurisdiction.
Right.
By making it your special jurisdiction by withdrawing and redepositing.
All right, now that's what I needed to hear, I guess, more of. Because
by repudiating their repudiation. By acknowledging the trust.
That's it, right there. That's what I was thinking, but it was kind of throwing me to the left a little bit because it was speaking of, dispensed with or an abolishment if the confidence of the court can be otherwise obtained. And I was just thinking to myself, like, how can you obtain the confidence or that confidential relation of the courts unless it's done in an equitable manner?
Right, because on the one side, on the one side they've been talking about at law, but if you can do it otherwise, then that's what you would do. So the only other way you could do it is trust, equity.
Okay. Now,
and when we gain confidence, we relate, which is what trust is. So the only way that you can relate to the court is by not doing it in the debtor-creditor public side where you're a fiction. The only way you can relate to the court is by acknowledging the trust in confidence, by actually relating.
Yeah. How do you give your name to the court?
Right. Eric, when you say relate to the court, are you speaking of it in a term of being synonymous with having something in common?
No. By speaking to the court as a real man, by acknowledging the trust so they can actually acknowledge the real man, not the court, not the public side, but the court, because we have both public and private.
So you're the court also. Or in fact, you are the court.
Yeah, because they got nothing if we're not standing in there.
But then the real man only by record can be seen in courts.
Yeah, that's why you make a record so that you can get into the court. You always have to go through the at-law side to get into equity. So the only way that they can see you is by record, because they look at you as a fiction.
Right, so that means we would have to demand that the entire proceedings be for and on the record, because if it's not, then you're just there for no reason.
That's right. That's what I said before when we were talking about jurisdiction. It would make sure that you're in a court of record so that whatever you say can be proven and can be seen, because that's the only way that they can see you is by record, because you're the straw man or the fiction man is a man of record.
And I'm glad you're speaking about records right now, Floyd, because continuing on in the same footnote, page 995, still under section 731, left side of the page, bottom footnote, it says, thus, documentary evidence establishing complainant's equities and his right to relief will suffice to warrant the court in granting an injunction, and such evidence may be presented by properly verified copies of private instruments or of records, when such is the appropriate mode of proof.
NOI, SOI.
Absolutely. So, just for the people, what would be properly verified copies of private instruments? How do we do that?
Well, you've got you have your UCC1, your UCC3, you have your affidavit, and let's see, what else do you have? That pretty much covers it, doesn't it?
Yeah, those properly verified copies of private instruments would be certified copies. Exactly.
Certified by who?
By the holder. Whoever the holder of the original is. Now, and it's speaking of private instruments, so that means we would be the holders, because it specifically said presented by properly verified copies of private instruments. We would be the only ones to hold our private instruments.
Right.
So how do we properly verify copies of our private instruments just for the people?
Well, I do mine. I do mine by notary public.
Okay.
Which is one way. We could put a thumbprint on it. We could put a wax seal on it. We can emboss it.
Can't we attest to the fact that it is a true and correct copy of a private document?
Well, that's what your affidavits are for.
Right.
Yeah.
And now the next thing is, which is another big thing, it says it is sufficient if the affidavit be in the form prescribed by statute. So we have to make sure that our affidavits have all of the proper elements in it, so it's accepted and admissible as part of our evidence. Now, continuing on, it went on and says, a bill of injunction may be sworn to by the agent or attorney of the plaintiff, but if so, it must appear from the verification of the person verifying the bill, knowing the contents thereof. Otherwise, the verification is fatally defective. Now let's read that again. It says, a bill of injunction may be sworn to by the agent or attorney of the plaintiff, but if so, it must appear from the verification that the person verifying the bill knows the contents thereof. Otherwise, the verification is fatally defective. Now, people would have to ask themselves a question. Do the agents or the attorneys for the plaintiff, which in most situations is the bank, do they ever swear to anything?
Nope.
So it goes on to say, otherwise the verification is fatally defective. So that might be something that might be able to use. We might be able to use just on a litigation basis.
Yeah, you have to.
But the challenge is, Marshall, they're not going for a bill of injunction.
Say that again. He was breaking up, Eric.
The problem is that when they come at people who've to foreclose on their mortgage, they're not coming at them with a bill of injunction. Because it says a bill of injunction may be sworn to by the agent. They're not coming with a bill of injunction.
What now if when the sheriff comes and shows up at your door with an order, is that not an injunction?
Okay, at that point, I thought you meant the bill or the complaint that they put into the court. Okay.
Oh, no. Now, and another thing that I wanted to ask about was, it says, now this would have been another situation where it was stating that besides irreparable injury, it was stating that in certain other jurisdictions, like in West Virginia, like what I'm about to read, notice is not required. Although it's general practice in most jurisdictions, notice is not required here, and listen to why. It says, now I'm reading same page under section 731, page 995. It's actually the second paragraph before the footnote started. And it
beginning
says,
with what? Beginning where, Marshall?
As perceived from.
Okay, I'm with you.
All right. Once again, people, section 731, page 995 on the PDF, page 948 on the document. It says, as perceived from the language of the statute, remember what it just said, as perceived from the language of the statute, the matter of requiring notice of an application for an injunction to be given is left to the discretion of the court. Yet, judging from the author's personal experience and observation of the practice in West Virginia, it is not usual to require notice of the application or motion before awarding an injunction, for the reason, presumably, that a bond with ample surety, here it is again, for reason presumably that a bond with ample surety conditioned to pay all costs and damages that may be incurred or sustained by anyone in case the injunction should be dissolved, it is essential to the operation of the injunction. So now here it's stating that it's not actually required to give notice, but it is required that a bond be put in with your injunction in order to have it validated, looked upon, and signed off by the judge. So that's
so if you don't do something right based on your injunction, that they can award damages at law. Exactly.
But it was just real peculiar how in one jurisdiction is necessary, as it seems, to serve notice of an injunction, whereas in another jurisdiction, all you need to have is a bond, an injunction bond.
And something else I want to point out about this bond that you just read about, and you read this earlier, but I want to put these two together. In the footnote on page 995 under 731, right column, it is sufficient. A bill of injunction may be sworn to by which means must, may be sworn to by the agent or attorney of the plaintiff, but if so, it must appear from the verification that the person verifying the bill knows the contents thereof. Otherwise, the verification is fatally defective.
Right.
Okay? And I want to point out that if it's not sworn to, the bill of injunction is fatally defective.
Right.
Okay? So if you have a bill that's fatally defective because it wasn't sworn to and there's a bond, then if we know how to traverse through the private equity.
He's in and out. Eric, you there?
Yeah, I'm here. Can you hear me now?
No, you're sounding bad, bro.
How's that? Still there, huh? Yeah, I'm going to have to talk to these internet people.
No, now you're good now.
All right. What I was getting at is that based on the fact that we have a bond, and if the injunction is dissolved, for example, because it's fatally defective because it wasn't sworn to by the agent or attorney, then we can go and traverse through the private side to get into the public side and order not only the performance for relief, but also order for award on the public side for damages.
Right. But as long as we're doing it through the private side first, right?
Right. But of course. But my point being about this is that for these sheriffs that come out and serve these bills for the injunctions, if we know how to look at these bills and see that they're not sworn to, there's a bond that we can go after once we go through private equity to order the award of. But just keep that in mind when you're looking at these bills that these sheriffs are serving on these unlawful detainers, for example.
So are you saying that, well, no, let me get this straight. So the sheriff who comes with this order of an injunction,
which is not sworn to.
Which is, that's what I was just about to say, Floyd, which is not sworn to, do you think there's an underlying bond somewhere that is giving it some validity?
If no notice has been given, then there better be.
Right. I'm asking a question because I'm sure that there's somebody out there who may be thinking the same thing.
Well, it's probably going to be different in different jurisdictions, obviously.
Right.
So research your local jurisdiction and find out if that bond does in fact need to be in place if they fail to give proper notice.
Well, this book kind of made
proper notice, or if they do give notice, make sure they did proper notice.
Right. Well, this book made it real easy for me. The book made it easy for me because it said here in North Carolina, notice is mandated.
Okay.
Definitely.
Well, this book was written with West Virginia and Virginia in mind.
Yeah. And I'm right. We're real close.
Yeah. Right.
But maybe that's something we need to be looking at, is to find out whether or not these bills are actually sworn to. Go ahead, Floyd. I'm sorry.
So I was just going to ask you then. So what you're basically saying is that if these bills are not properly sworn to, that when you go into equity and you get your relief, then you can come back at law and you can sue them for their bond?
That's what the book says, my friend.
Yep.
Oh, wow.
That a bond with ample surety, conditioned to pay all costs and damages that may be incurred or sustained by anyone in case the injunction should be dissolved.
So if I go after them for pain and suffering, or whatever, then I should be able to put a price on that.
Right, because from the beginning or from its inception, it was all done in fraud.
Yeah.
Because it was your right that was being harmed or injured from the beginning. It was trespassed upon. Is just that the good thing about trust is we can come back, re-express the trust, and start claiming our rights and injuries to our rights and trespassing of those rights. And that would afford us damages on the at-law side, going through equity to do it.
Yeah, I just had somebody the other day ask me about what if there was something that wasn't satisfied in equity. And basically I told him this, but I didn't know about the bond at the time I was telling him about this. Wow, that's good. That's great.
So now, it was something else that was in here that I actually wanted to read, where it was making a strong case for making sure that notice, because it seems as if more jurisdictions lean towards proper notice than anything else. But like I said, we also have to keep in mind the factor of the irreparable injury. So we definitely want to keep that in mind, people. If you know how to put your bill together and show that your rights, your equitable rights are being trespassed upon now, that there is your irreparable injury, it has to be specifically stated on your bill, and that would get you around the whole notification thing. But if it's not something of that manner, it's strongly advised that you would want to play it safe and serve proper notice, because page 996, down at the bottom in the footnotes, once again, page 949 on the document, page 996 on the PDF, down at the bottom it says, the principle where laid down in Foster Federal Procedure Section 231 is founded upon Equity Rule 55, governing the practice of equity in the federal courts, and of course is not really applicable to our state court in the absence of a like rule or a statute of the same import. So it all has to be comported down to your state court, your state rules of evidence, your state procedure when it comes to civil proceedings. Now it says, Mr. Spelling, discussing the doctrine of notice, says, unless a pressing necessity be shown. Now, keep in mind, people, that pressing necessity would have to be your claim of an irreparable injury or some type of special or exigent circumstance. Unless a pressing necessity be shown, a temporary injunction should not be granted without notice, nor except upon a case clearly made showing an equitable right to the interference of the court, a substantial ground to apprehend such loss or damage as cannot be compensated. So we have to make sure, like, we want to play it safe, it seems like to me. Sounds like, fellas, that we really definitely want to make sure that due process stays right in the forefront of our brains, and that proper notice of what's going on is administered to the proper parties. You agree?
Yeah, I agree.
Okay. And it goes on. And yet, where the injunction is granted upon notice to the defendant, the fact that many of the material avertments of the bill are stated upon information and belief will not prevent the granting of the relief where defendant is in no manner denies such avertments. Now, an avertment, just in case people don't know, in pleading practice is a positive statement of facts in opposition to argument or interference. And when I looked up the word avertment, it took me to particular avertment. And you know, when we see these words, particular, exigent, special, and all of that stuff like that, it kind of raises an eyebrow. So particular avertments are the assertions of particular facts. Now, the particular facts, what would be an example of a particular fact?
Well, something was done specifically to me.
Okay, and that would be an example of what, Floyd? Wouldn't that sound like an SOY?
Well, yeah, and generally what we're talking about is trespassing on our rights.
Right. So,
actually, what Floyd did is Floyd made a claim. Floyd did not supply the evidence of a particular fact, did he? He said something was done, not the fact that shows something was done.
Hold on, you was breaking up, Eric.
I said, actually what Floyd said is Floyd made a claim. Floyd did not provide the evidence that a particular fact exists.
Right,
okay.
You have to. That's right. You have to put in what exactly
the evidence thereof.
The particulars were, yeah.
You have to put in the evidence thereof the particular fact.
Okay, so a particular avertment, it says, are the assertions of particular facts. So would the particular fact would be
well, he grabbed me from behind, he threw me on the ground, and he broke my arm, and he cracked my rib. And
here are the x-rays.
And the particular fact could be two witnesses corroborating your story and the records from the hospital showing you have cracked ribs. That would be the particular fact.
Okay.
Because two witnesses make it a fact.
Right.
Now, if two witnesses didn't see it happen, then what am I going to do now?
Then it's not a particular fact if it's one witness.
Yeah.
In this context, now there might be other ways to create facts, but in this context, it's not a particular fact.
Mm-hmm. Okay.
All right. Moving on to the next paragraph. Anything, you guys got anything else you wanted to add?
I'm going to read over that again and just make sure I got it all.
Say that again?
I got to read over it and make sure I got it all and make sure there's nothing else there, because that was a pretty good little sentence there.
Absolutely. So hold on, let me just read the whole paragraph again to everybody.
That'd be fine.
All right. Mr. Spelling, discussing the doctrine of notice, says, unless a pressing necessity be shown, a temporary injunction should not be granted without notice, nor...
What is a pressing necessity?
We spoke about that before, just 2 minutes ago.
Okay, sorry.
No, it's all good. We can go over it again. What is the pressing necessity? That's when I stated that we would have to really know about our special circumstances, our exigent circumstances, and our irreparable harm that we would be claiming.
Oh, and by the way, that's what makes a notice valid, is that the person that's putting it in is the only one that knows the facts from his point of view.
Right.
All right. Reading on. Go ahead, Marshall. A temporary injunction. A temporary injunction
should not be granted without notice, nor except upon a case clearly made showing an equitable right to the interference of the court, a substantial ground to apprehend such loss or damage as cannot be compensated for. And yet, where the injunction is granted upon notice to the defendant, the fact that many of the material avertments of the bill are stated upon information and belief will not prevent the granting of the relief where defendant is in no manner denies such avertments. And remember, an avertment is a positive statement of fact in opposition to an argument or interference. I think this next paragraph kind of ties some things up also. It says, the same learned author further considered the subject of notice of application for injunction says, even in the absence of statutory provisions on the subject, courts of equity have undoubted power where the urgency and necessity of the case, as shown by the bill or bill and accompanying affidavits, require it to grant a preliminary injunction without notice to the defendant. But in the absence of this pressing necessity, it is improper to do so.
All right, what really jumps out at you, what you just read, Marshall?
Well, what really jumps out at me from what I just read is the fact that equity, having that undoubted power, will grant you that relief that you are speaking and that you are needing of immediately if you can show that there has been an irreparable injury or some type of a pressing matter, and equity will afford you the relief in which you seek.
How about you, Floyd? What jumps out at you?
Well, basically, what we've already covered is what really I've been looking at most all evening, and that is how we get into equity, and how equity really does work for us, and that the courts do not have any jurisdiction over the private man versus the public man, which they do have.
What jumps out at me from what Marshall just read was, even in the absence of statutory provisions of the subject, courts of equity have undoubted power where the urgency and necessities of the case, as shown by the bill or bill and accompanying affidavits. As shown by the bill or bill and accompanying affidavits is what jumps out at me.
Okay, everything in record, exactly.
Right, but it shows that we got to put our bill together properly, and we got to have the right records and the accompanying affidavits.
Okay.
In order for it to have some effect to grant a preliminary injunction, for example.
Right.
Right.
I
just want to make sure that really is something that we really key in on.
Yeah, I think we should take some questions now, don't you, Eric?
Sure, that'd be great.
Hold on, before we do that, it was something else that I had just wanted to go over real quick, if you don't mind.
That'd be fine.
Yeah, just something that I wanted to bring out. In the next section, in section 732, it said the order awarding the injunction. Now, this is page 997 PDF, section 732, page 950 on the actual document. And it says, if the injunction be awarded in term, it is entered in the order book as any other decree. But when allowed in vacation, the order is addressed to the clerk, is written out and signed by the judge, and frequently is endorsed upon the bill or petition asking for it. While it is usual to commence the order with the style of the suit and follow then with a recital of the presentation of the bill, its exhibits, and the reading of the inspection the reading or inspection thereof by the court or judge with an award or of the injunction in specific term. Now, what I wanted to talk about was the word term, because it was about the third time that I saw the word term and vacation, and by the time I got to this point in the book when I was reading it, I said, I need to know exactly what they mean by term. So I went to term, and I got 3 definitions of the word term. Now, it said general term. Now, these are definitions from out of Black's Fourth. It says general term, a phrase used in some jurisdictions to denote the ordinary session of a court for the trial and determination of causes, as distinguished from a special term. for the hearing of motions or arguments of the dispatch of various kinds of formal business or the trial of a special list or class of classes. Now, it had me go to the word special term now. Now, it says, in New York practice, that branch of the court which is held by a single judge for hearing and deciding in the first instance motions and causes of equitable nature is called the special term, as opposed to the general term held by 3 judges usually to hear appeals. Now, I wanted to know and glean a little bit more information about this special term, and why is it that a single judge hears the I guess the proceedings of a special term, whereas in general it's 3?
Because you're in chancery.
And we would only need to deal with 1 judge.
Right.
So does that denote that we can't have a private panel of judges?
Why would we need it?
You don't need it.
I'm not saying we need it. I'm asking, could something like that be done? I'm just thinking a little bit outside the box. I know all we need is 1, but it specifically stated 1 judge, so it had me, ask myself the question, could there be a panel of, say, a private judge, a panel of private judges?
Probably not.
Probably not?
Yeah. I don't know if you get into chambers, that's what your goal is anyway. And once you get in chambers and you prove trust, that's really basically all you need to do. It only takes one
judge to sign the order.
Yeah, because if that's your dib hearing.
Yeah, it takes 1 judge to sign an order, but it sure doesn't take 3 to hear appeals, like it says in the definition. And that was the reason why I asked myself, just on the flip side of it, could there be a panel of private judges? Now, I've never heard of it before, but I just wanted to ask that question just in case somebody had something like a different ideology or way of thinking as far as that was concerned. But
well, one side you're dealing with at law, the other side you're dealing in equity, and when you're dealing at law, they want to cover their rear ends to make sure that they have their 2 witnesses in whatever decision they come up with.
Sounds good to me. I just wanted to ask the question.
And realize on the outlaw side, they have a public insurance policy that they can't have claims on. So maybe for that reason, the more judges that they have sign the order on the outlaw side, the less chance they're going to have some malpractice claim against them.
It's a possibility, right?
Because, remember, 2 witnesses make something a fact.
I have a question.
Sure.
Many people have asked for injunctions. Do you think they have been granted?
I know there's a lot of injunctions that haven't been granted, but most of the time it's because they haven't been asked for properly, and they probably haven't been put in correctly.
That's the next question I was going to ask. Many people have asked for injunctions. The injunctions have not been granted. And my next question would have been, why were they not granted? Because the injunctions are so willfully deficient on the basic elements and everything. And they don't do any study on their own. And maybe one little thing is left out, like they forgot to put the bond in with it.
That's not a little thing.
Any one of the little things will get you no injunction. And then you're going to say, oh, not just the injunction could be deficient. What else could be deficient?
Failure to state a relief upon which the court can grant. Well, failure to state a claim that the courts can grant relief.
Where's that listed at?
As far as the injunction is concerned?
No, outside the
injunction. That would be in your bill.
Other than the injunction being deficient, what else gets you hammered?
Other than the injunction?
Improper procedure.
Let's just admit the injunction is defective.
Okay.
But what else gets you hammered?
Improper procedure.
How long do you want to make the list?
Improper procedure in what? In what respect?
Well, the courts all have the courts have certain rules that they go by, and if you don't know what the rules are and they don't follow them, you don't get hurt. Yeah. In other words, how do you get into a court of equity? How do you invoke a court of equity?
Well, first you got to make sure it is a court that hears equity cases.
That's number one.
Yeah, that's number one. Yeah, that's the
Yeah.
Well, I've heard that people didn't know they weren't in a court of equity.
Yeah, well, that just shows us how most of us are so dumb. But anyway,
number two, you have to show up.
Get into a court of equity. What else does it take?
It takes a proper bill.
Bill in equity.
Yeah.
A bill in chancery. And your bill in chancery or your bill in equity is also deficient. And you get heard that way.
But how many people actually put in bills in equity when they don't even know about the equitable side of the courts?
Well, the point I'm trying to point out is we're so deficient in everything that we do. We need to start ramping things up, and we need to get more educated because, just like the scriptures say, you are perishing for a lack of what?
Knowledge.
Knowledge. Do not ever depend upon anyone else to learn anything for you. It will never happen.
Absolutely.
You've got to know it yourself. And I don't care whether you say, I don't have time to learn all this. The fact is, you've got to know it. That's the reason why we're in such sad shape now.
Well, when this country was first formed, back in the 1600s and 1700s, the man of the house carried a Bible in one hand and a flax in the other one.
They held court on street corners that were more, anybody walking by could have participated in it, and they knew exactly what was going on because they all knew legal matters.
Right.
All understood that stuff. And we have lost that basic knowledge. Created a society of brain-dead people that don't know how to tie their shoes. Can't put an affidavit together. Can't read more than 10 pages without falling asleep. Got to have video games to stimulate their lobes of their brains rather than a good book. And all they want to do is play.
Comes a day when you got to reach the age of majority. You can't be an infant or a minor anymore. You can't play all your life.
Right, and that's why there's only so many people in this who you never hear about that are actually the people that are in charge, because they're the ones that have been trained as the kings since little on. And then you can't expect to learn all this stuff and jam it up in 3 months. Something that was taking you at least 20 years. But you got to realize this is your life. And he who sleeps on his rights has no rights, has no life.
Well, most of us have been educated to let others do it for them. That's the reason why attorneys are so popular today, because people don't want to study.
We'd rather go to an attorney and let the attorney represent us and take all our money and lose the case and lose what we got, and we think we're winning.
Yeah. Yeah, that's true.
You can't get an adequate remedy at law even when you win.
That's right. But that's the mindset today. You hit the nail on the head, and that's one of the ploys in the system is to keep us so busy we don't have time to stop and learn what we really need to learn.
Yeah, and all you have to do is get off the treadmill.
Yeah, right.
You got to break. You got to break the cycle, and you're the only one who can. You got to get off the treadmill.
They got us so wrapped up in this fiat system.
The deficiencies and the injunctions, it really rests on, number one, the pleading.
Right.
First, it's like you got to understand NTT, but if you can understand NTT, which is the simple part, the harder part is you got to go into their courts as it stands right now.
Absolutely.
And you got to get in there with a proper pleading. If you want to save your house or your mortgage or whatever it was, you got to put an injunction in there, and the injunction is going to rest on the pleading. If your pleading is defective, your injunction will be worthless. If your injunction is worthless, your pleading is also going to be not getting what you want. But everybody says, well, this stuff is too hard to do it all. It says, no, it's not. You just never learned it before. My eyes hurt. You just never used them. My brain hurts. No, you just never used it.
I tell you one thing. I spend more time lately learning process and procedure and knowing how to put together these things than I do actually, like CW said, like the NTT. That's the easy part. But trying to figure out that whole world of fiction over there, that is a task.
And we are making it too hard ourselves. It's not that hard. What is hard is to unwind all the garbage that you've learned and to put it in simpler terms. Because once you know the rabbit trail path, that's the simple path. But how much crap did you have to look through to get there?
Yeah, well, when you're used to coming up with 15 pages of interrogatories, and all of a sudden you're down to 2 paragraphs, it seems like something's missing.
Yeah, but why do I want to play around with 63 million statutes and codes when all I got to do is fool around with 12 maxims?
Exactly. Yeah. That's
you must be a sadomasochist wanting to go into there and get beat up.
Yeah. Yeah. I guess it's hard for people to understand and accept that it's as easy as it is.
Well, but that's the only way they've been brainwashed to be famous litigators, and so where they can shine in litigation, and think you're winning, then beat your head against the wall. Go ahead, be my guest.
Yeah. Yeah.
This Skype is breaking up really bad.
Who's breaking up?
The pleading is
Skype.
To get it into a court. Somebody threw at me the thing that was talking about the hypothetical court case that the parties' notices were being denied, and the UCC registrations were being ordered to be canceled by the court. Now, number one, there's not enough information there to base any kind of judgment on at all. It all depends upon what was your bill in chancery. Or do you even have one? What was your indenture? Do you have all the proper methodology under NTT that the courts are going to recognize that there was a trust? Or was there nothing there really, and all they got you on was that they're going to do a outside denial and order all these filings closed, and you don't know what to do because you're stymied? Because you thought that these people were going to roll over and play dead on you. Now, why would they cancel your UCC? Why would they order the court to? I heard this before just recently, but they're coming back and they're ordering the filing changes, reversing the filings on the UCCs.
They're trying to make us deficient of proper records.
Right.
Because in the court of law, and even the equitable side of the courtroom, like a record is a record, and it goes back to having those two public witnesses. And if they're trying to take these public witnesses away from us, we have no records. We have no records. There's no case. We have no prima facie case. So, CW, let me ask you a question. Being that the year of the equitable pleadings book that you and I went over was from way back when, but then this new book that we were reading out of today is post-Supreme Court changes, do you think that it would be a better guide of putting together our bills, or can we just kind of equilibrate between the both of them?
Well, we're treading on so much new ground, with this. Nobody's talking about trust, for one thing, and operating under trust as an offense under NTT. But not only that, nobody is operating in court under equity. So everything that we are doing is totally new ground. And we only have a limited amount of people, and you can't push on all fronts the amount of dirt that we need to push to save everybody's problem. There's no way in hell that we can do all that. Number one, we need more help. Number two, we need help that is qualified and up to speed, that has a total background of NTT and trust, and preferably with some court smarts.
Right.
Now, that's a pretty stiff bill to begin with. And that just doesn't happen overnight, right, Marshall?
Absolutely not.
Because just tell everybody how many hours you put in so far just to get to where you were a TA.
Wow. Whew.
1,200 hours, right?
Yes, sir, it was 1,200.
Now, don't expect some newbie to come on the call and expect to sign their name on an indenture and expect to know all about it.
Right.
Or to solve your immediate problem, which is to get thrown an injunction into the court to stop your foreclosure. It ain't going to happen. But when you get knocked off that horse, you got to get back on it. Because the only time you lose is when you finally give up and you don't get back on the horse. So don't expect that you're going to win on the first try, because we're pushing too much new ground here. And you're asking for documents that, number one, you don't understand. Number two, they don't even exist yet. And number three, you don't have enough time to learn it. So cut us some slack here on some of this crap that some people are talking about. And then also, stop looking for the easy way out. You all want to see some successes, but you're not listening to some of the past shows because there have been successes.
Yep.
And there's other methodologies that are being touted out there now that are so simple, that are so unscriptural, and yet they're talking scriptures, that it's pathetic. And it sounds like the itching ear, what you want to hear. But in reality, it is the wide gate that you're going through, the one that looks all easy path, rather than going through the narrow path, which is the one you got to study your ass off.
Okay, we're back.
All right. But I start thinking about this false trust stuff that's out there right now. It's no different than the debtor-creditor realm. And I'm going to issue a warning. They're talking trust, but it's not trust. They're telling
Unmuted.
to a court that you don't have to go into court, and all you got to do is just say, this is a trust, or this is an executor. That is freaking BS, because this public side realm only recognizes one kind of form, one kind of procedure, one kind of process.
Debtor-creditor.
Them that you got to listen to us, and they're not going to. They want to see what they got to see according to their form, process, and procedure, and you got to prove that there is a trust. You can't just come walking in there and say, this is a trust, and I'm the executor on the trust. It ain't going to work. That's no proof of any trust.
Certainly doesn't conform to page Gilbert's.
Nope. And you're going to fall for the easy way out, thinking, oh, this is so much simpler, but yet it's trust. No, it's not trust at all. There's no trust in existence until you prove a trust. And if you don't prove a trust, there is none. But they're winning by default because of an unrebutted answer. Until these judges and these attorneys, and it won't be too long before they start saying, we don't see a trust. And then what are you going to do? And that's already happening now. So you've got to be wary. Everybody that says, oh, this is a trust methodology, you better know what a trust methodology is, or else you're going to be snow job. And it's a strict violation of the Scriptures because it says, agree with your adversary quickly, lest he throw you in jail and extract every penny that's due. And what you're doing is you're running from your obligations that you set up under debtor-creditor contracts, colorable contracts, setting up an obligation that you must live up to. And we are living up to that obligation by merging the titles in payment of that obligation, and then we're terminating the trust. So we're not violating the Scriptures. This other methodology is. You're walking away from the obligation and saying, I'm not going to honor that. I don't know one place in the Scriptures that says that God doesn't honor His Word. If you want to walk away from your word is worthless, and I'll never listen to you.
Mm-hmm. So, once again, it goes back to how important it is to make sure that our bill is put together correctly and it is not deficient of the critical elements that need to be in it.
This is an example of an order issued by some court, hypothetically. Say, the court is denying the appellant's third application for extension of time to file a brief, and reminding him that, pursuant to the court's order of such and such, the brief was to have been filed on or before such and such a date, and no further extensions were to be granted. And the motion for reconsideration of that order is hereby denied. Furthermore, the register of such and such, as well as any other division of the court of so-and-so, is hereby ordered to strike any and all UCC documents filed by the appellant, referred to as such and such, blah, 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 in any capacity whatsoever. And because of appellant's failure to file his brief as directed, the appeal number such and such is hereby dismissed, and the application to relief filed is hereby denied, and as moot, denied as moot. So this is just not enough information, because I'm going to ask right off the bat, what was in your bill in equity? And why didn't you file a timely brief? They're going to find all kinds of ways to hammer you to the ground, especially when you come in the at-law side and try to argue it. And you missed your opportunity probably to get into a bill into equity through a bill in equity. But then I don't know enough of what this particular hypothetical was to really say. So. But what tells me just from this order is that you're not paying attention to the form, the process, and the procedure that they will only see in their room.
So, Christian, just so people can hear it from you, where is the place that they need to go to learn form, process, and procedure of the at-law side?
Well, fortunately, you really don't have to. All you have to know is just enough to get you into equity and know how to hold equity.
Right.
But really that involves a whole lot more, because there's so many ways for you to get tricked off a course and hauled into the at-law side, so many ways, probably due to all the inexperience, because you don't know what you're being asked. And you're either saying too much, not saying the right thing when you need to, or else you're dead silent. To effectively hold equity and keep you out of at-law, simple, absolutely simple. But to get to that point, you're going to have to know a whole lot more of the at-law side.
Yeah. And that's what I meant by asking that question that I posed to you for people that may be out there. Would it be learning civil procedure and, rules of evidence?
First of all, you got to read the rules of evidence. You got to read the rules of the court. If you haven't read them, you shouldn't even be in there.
Right.
Well, I don't have time to do all this. Well, hey, better be satisfied being a slave then.
So it would be rules of evidence and civil procedure then?
Yeah, and then the local court rules, too.
And local court rules, okay. Rules of evidence and local and civil procedure.
Yeah, there is no way that this can be made so simple that everybody's going to be able to put their name on it and just throw it at some wall and make it stick. It's going to take knowledge, and there's only one way. You've got to study to get the knowledge. It says the hearing comes by the word. If you want to get more word, more faith, you got to read more word. Faith comes by hearing, hearing by the word.
Christian, is it mandated that we have an evidentiary hearing to get our evidence properly put into the courts?
Well, nobody can take your rights away without due process, which means you have to have an opportunity to be heard.
Right.
But what side of the court is that opportunity to be heard on going to be on? Is it going to be in equity, where your rights are, or is it going to be at law, whether you've been given a privilege and they're going to take the privilege away?
So this evidentiary hearing, wouldn't you have to still go through the gatekeepers the same way?
Yes, because that's the gauntlet that you must run. If you
Right.
can't the gauntlet and get through, then there's I'm sorry, that's just the way the system's designed, and we have created that system. You got to dance on the stage on the Dog and Pony show, dancing to their tune, their song, playing with their tools, so to speak.
Right.
Unless you know how to play in equity, and you can bypass all that.
Right. Once again, I'm asking you these questions because I know there may be a few people out there who are thinking the same things, who really don't have too much of an understanding of what you're talking about.
Many people don't have an understanding of what I'm talking about.
Yeah. Right. I tell you one thing, I myself, just hearing you say what you said tonight, it's been a good little while, probably a little over a month or so since I've actually really dove headfirst into the rules of evidence and, the procedure. And just from hearing you speak tonight again about it, because I've been so much into CJS as far as equity and enforcement of equity and banks and banking, I've been doing so much of that lately. I kind of veered away from something that I remember from early in NTT days back in, I think, December. You were really harping on, rules of evidence and procedure. So that was the first time that I've actually heard it. So, like I said, it's been probably a little over a month since I've actually read into it a lot, but it's definitely something I have to balance with CJS because it's critical for us to know exactly what's going on the at-law side of the courts. We have to run the gauntlet, just like you said.
You got to know what you're fighting. You got to
Right.
know how they're going to trick you. If you have no idea, then you're going to fall right into the traps.
See, now that would
really
be...
Really
that would be that would be the scary thing for people, though, Christian, because you can prepare, you can train, but for a lot of people, once they step inside of the ring or the arena and they don't know what to expect, it's a totally different ball game from training and actually being at war now.
But how many times have they gone to court and listened to the court cases for a day?
Absolutely. That's something that people needed to hear. That's what I'm talking about right there.
Or they just wait for you to have some little kosher little talk on for some kind of courtroom mock court. What are you waiting for? Get off your lazy butts and go down to the courthouse and listen to what's going on in real life.
That's right.
You'll get all the first-hand knowledge you want to see and hear down there. Write them down. Bring them onto the call and say, here's what I found out. No, everybody's paper on the call, sitting there not doing anything but listening, and they don't contribute anything.
And that is a great idea, Christian, because that's something that I know of, but I won't lie, it's something that I had totally forgot about because of there's so much to learn between NTT and the at-law side of the courts, and balancing the two.
If we're really operating in love looks for the opportunity to give. What are you guys giving? Or are you just sitting back there and taking everything all in? A bunch of takers, which is the spiritually immature people, or the takers. They come to church and take everything out of the church, but don't come to put anything back in. What are you contributing? The spiritually mature contribute. Give something back. It's more blessed to give than to receive.
Absolutely. That would be like a really, really great idea, people, for just to be able to go to a courtroom and sit in the back room and be a fly on the wall and listen, because especially I've actually done it before, but not in this venue under NTT, but I've been in courtrooms before, and sometimes, with friends and, just people that I know. And when you go in there, especially after studying NTT, when you listen to the verbiage that these guys are using inside of that courtroom, where you would hear about trustees and beneficiaries, but it goes by so fast and it flies over your head, on top of the fact of everything else that you're really not paying attention. But if you go in there with trust eyes and trust ears, I believe it will really, really start waking some people up about what's going on. And I myself, I'm about to make that a habit of mine also, just going down to the courthouse when I do have the time, of course, to sit there for an hour or so and see what I can glean from just listening to these judges and the prosecutors talk to each other, and see how the plaintiffs, the trustees that we're coming in, the office that we're coming in under, how we're just burying ourselves in a debtor-creditor realm.
Yeah, and you may find some party there that has been held back to the very end, and then you could stay over and listen to what happens in the very end.
Absolutely. That's a great idea for those of us who may have the time to actually do something like that. I know a lot of people work 9 to 5s, but for the people who don't, or if you could take a day off of work and you have some type of proceedings or actions that's coming against you, that is some great advice, to actually go down there and sit and listen.
You know, I'm sitting here listening to this, and I'm thinking back at my past, of what I've gone through going through the courts, and I don't know how many times I would say things in the court, and they would pull me over until, the very last to come up, because of what I was saying was very dangerous to the rest of the people in the court. Mm-hmm. And, these were just traffic tickets and some other things, but, I can count on, I can't count on my hands how many times I've been in the court, and it's occurred to me, and I look back and it actually occurred to me doing that. I don't know how many times, 20, 30 times. I've spent a lot of time in court. Just minor things, nothing major. But actually fighting, because I was in the Patriot movement, and I was fighting them with the debtor-creditor stuff, and some of the stuff I was saying, the judge couldn't allow it being heard into the courtroom, and he held me over, and I'm sitting there by myself, waiting in court, what's going on here? And then it dawned on me, they don't want me to hear, they don't want other people to hear what I'm saying.
Yeah, now why?
You're waking people up.
Well, no, not only that. It's that there's a trust here. The two sides of the court, the public side of the court and the private side of the court, just like anything else, has been segregated. It's in trust. And now you're coming in with your private side stuff in this public realm, and you are breaching the trust yourself, and they cannot allow that. So they create a private nature to the court to, here it is, to protect you from breaching your own trust.
Mm-hmm. Absolutely.
So they are protecting the two sides, protecting the trust by doing what they're doing, and nobody looks at it that way. They're actually keeping you from breaching your own trust by saving you to last when you talk about the private nature of the stuff in open court. They shut you down and save you to last, and usually there's nobody else there. It's in private nature. Because if you breach the trust, then they'd probably have to throw you in jail and give you a worse time that you had before. Because you're the one that's commingling. You're the one that's breaching it. You're bringing the private nature in and making it public.
Yep, and I've spent time in jail for my mistakes, for bringing it out.
Yes, now let's learn that and use that as an example and say, oh, no, I shouldn't say all that stuff in court like that. It's going to get me into trouble. They're going to hammer me in protection of my own providence.
I've learned a lot over the years. I've spent some time in jail because of my mistakes, because I thought I knew what I was doing. And, of course, it was all at the at-law side, and I was just, like you said, I breached my own trust. I commingled it.
So now at least we know what's going on, and it's all been trust, and now it's equity is what's enforcing the trust. And now how do we get back into a court of equity? How do we maintain our private rights, but yet get our private rights expressed in such a way that we can get them enforced?
Christian, how important do you think a memorandum in law is for the lower district courts? Because there's a part of me that really believes that the way we would be invoking and using equity, I think their equitable skills as judges is a bit dusty, in my opinion, because I just don't see them. Well, when you get to the higher jurisdiction of the courts, maybe so, but then for a judge who does not utilize equity in this manner at all, like, do you think a memorandum in law should accompany that? Because I read a memorandum is really only held in federal jurisdiction.
Yeah, I think a memorandum should be included with it, but say a memorandum in equity and a memorandum for trust, say.
Memorandum in trust and equity. So now, in this memorandum, would it be feasible or would it be acceptable to quote or to quote from, say, out of American jurisprudence or CJS or something along those lines, being that it is public, because we're definitely not using statutes and codes.
Yeah, nothing is statutory since it's post 1933.
So then what would this memorandum contain then?
Well, the equitable maxims for one thing, and then it would contain trust law based on, say, something that they could recognize that they're going to go under, which would be, say, restatement of the second.
That's what I wanted to hear, something along those lines. Either I know we would be using our maxims, but I wanted to hear whether it would be feasible, like I said, for us to use, say,
the trust law that we're going to be implementing. We want the test of the trust, because it says in Gilbert's, the I section, it says first you got to test the trust, and if all the elements necessary for the formation of a trust are there and the method of formation,
you have a trust.
Then the law must recognize it as a trust.
Right.
But you got to give the court the law, and we do that on the memorandum. Give them the law, the test of the trust that they must recognize.
And that law, and see, now that would be the thing that I know some people might want to ask. Would reinstatement of the third on trust or CJS on trust, can that be considered as law to go in a memorandum in equity?
Well, I wouldn't say the third so much, but the second and possibly maybe just the first.
Okay. So I'm noticing that you're continuously making mention to the reinstatement. So would we want to stick to the reinstatement and not really deal with CJS when it comes to the memorandum?
CJS makes reference to this restatement. Gilbert makes reference to the restatement.
Absolutely.
CJS has got a lot of case sites supporting the restatement.
Okay, then, so we would want to definitely stick to reinstatement of the first and second, preferably the first. So our whole memorandum in equity can be citations or quotations from out of reinstatement of the first. Yes,
but the case supports pre-33.
Right, absolutely. Well, I know that's something personally that I would be doing, just in case, because I just have this feeling that some of these judges just don't know what's going on. They've been judges for 30 years, and they've probably used that side of the equitable side of the courts, the private side of the courts, probably once or twice, maybe in their entire careers, because it's just the same old monotonous everyday thing that they do on the at-law side. And I don't know, there's a part of me that also believes that the judges will be excited to see someone come in there who actually knows what they're doing, so they can grant them the relief, just to change up the tone for them, probably.
Right. I don't think all these judges are corrupt. I think very few of the judges are corrupt.
Right.
We got some cheap like everything else.
We got to give them something for them to work with.
Yeah, we're not giving them what they require according to their form, process, and procedures to get into equity. And then when we get into equity, we don't know what to give them there either.
Yeah. Okay, so off to the law library I go. Got to start photocopying this reinstatement now.
Well, that's why I asked for anybody out there that had a digital copy of the restatement on the first or the second, because I don't have the first, and I have the first 16 sections on the second. I have I don't have the first and the second.
Don't worry about it. I'm on it.
And we really need a digital copy, so. And then we need to put together a team that can work on a memorandum in equity that contains both an application to trust and an application in equity.
Absolutely. So now the reinstatement on trust, about how big is the book?
I think it's 3 or 6 volumes, I forget now.
3 or 6 volumes? I thought you was about to say, 300 or 400 pages. You said 3 or 6 volumes.
I believe it's a 3-volume set.
On trust alone?
Yes, just trust, yeah.
Wow.
First restatement on the law of trust, the second, and the third.
Well, I mean, I know that, but I'm saying, I'm sorry, I asked the question wrong. I know there's 3 sets. There's 3 volumes, reinstatement in the first, second, and third. But the first, how big is the book? Do you know off the top of your head? Is it, 1,000 pages or the same size as a CJS book would be or something along those lines?
Yeah, it's a 3-volume set. Yeah, just the first one, or just the second one, or just the third one. It's a 3-volume set.
Okay.
There's 3 volumes in the first restatement on the law of trust.
That's what you're saying. Each volume, each one has 3 volumes.
Yeah, each one. It's just a newer update.
Okay. See, that I didn't know. Because I'm trying to gauge in my brain how fast I would be able to get this stuff copied. So, we can
3 volumes, and they updated it, and then they came out with the restatement second. And then they updated it again. They came out with 3 volumes and the restatement on the third.
Okay. Well, I'm going to be working on the first.
First and second. Everybody should be primarily.
First and second. Okay. Is there a order of priority out of the first and second? Now, of course, logically one would think the first, but I just want to be sure.
1935, they made major changes in the restatement on law and trust.
1935?
And that was incorporated in the I think it was the second. And the second was good from then till, I think, 1958, and then they came out with the restatement of the third. But the first so whenever they came out with it, to say 1935. Then from 1935 to 58 is the second. 58 to present is the third.
Okay, so now, just to get something clear in my brain, since CJS is the body of law, why are we focusing so much on reinstatements?
Because they go hand in hand.
Okay.
Yeah, do you see it's like the total body of the trust law is in CJS, in its 100 volumes, say.
Right.
But to pull just the trust law out of CJS is now in the restatement in 3 volumes.
Oh, okay.
The CJS is now the case supports in support of the trust law and making reference to that in an explanation. But back to how to invoke a court of equity and how to maintain it. It's really simple. Just put it in your pleading, and all you got to talk about what's in your pleading.
Stick to the pleading. That's it.
And when you come up with this denial and this order to strike the UCCs, it's plain to tell me that you didn't present a trust. Because if you'd have presented a trust and got a hearing and got them to acknowledge your trust, they wouldn't be issuing any orders to strike your UCC documents because you already proved the trust. I'll bet you 10 to 1 you never proved the trust here, which is everybody's mistake. Because now you're not the 900-pound gorilla. You're on the at-law side, you lost.
Now, can this proving of the trust, can it be in any way, shape, or form done in open courts? Or does it have to be done by way of record in a judge's folder and you directing the judge to look, man, look in your folder. What you need is in there.
Yeah, how do I present material facts, SOIs? You got to get it before the fact finder. Who's the fact finder? The judge.
Judge, absolutely.
If he doesn't have any facts before him to make a finding on, a ruling, then what's going to happen?
So this is why it's important for our records to precede us before we get into any courtroom situations.
You're not going to walk into court and tell the judge there's a trust here.
Right.
That's just plain claim. That's frivolous without support. It's irrelevant, it's immaterial, and you don't know what the hell you're doing. Talking about all this stuff about NOIs, got to be supported by SOIs, and all of this stuff, you got to go back on the old tapes when we first started this 11/7. You got to listen to every last one of them. Every last one of them.
I can't wait to be able to do that myself.
We're losing because of not getting into a court of equity. You're not presenting your trust, and that's why you're getting hammered. And I realize that you're rushing before to save what you've got, but it may be that you have to lose what you have in order to make you mad enough to study your butt off and go back in and get it back.
Right.
You're being tested in God's wine press so that you come to the realization that you have a lack of knowledge and skill. And you need that knowledge and skill to be in control of your life. And if you don't, someone else is in control of your life, and you're the slave.
Sounds like a plan.
So we want to open it up for a couple questions maybe, and then call it a night.
Q&A session started.
Any questions, press *6 followed by 1.
Hey, Christian, how are you? Hello, Christian, how are you?
Yes, go ahead.
Quick question. I'd like them to touch base on that one bonding part that they were talking about earlier.
Right. Mm-hmm.
Can you touch base on that again?
Every injunction I ever looked at had to place in there for the bond. You got to have a bond hearing. If you didn't bond your injunction, you ain't getting one.
Okay, can you define that a little bit more as far as a bonding your injunction? A little bit more specific.
Yeah, you got to. If they're taking a house for say $100,000, plaintiff it might be possibly damaged for $100,000, and you, the defendant, have to bond the plaintiff for his loss. Now you can come in there and for good cause shown and say, well, plaintiff can't be damaged because he can't be prejudiced because number one, he's foreclosing on a piece of property that's not his and he has no right to foreclose on. And therefore, the bond the amount should be $10. Okay.
So in other words, some kind of bond. It doesn't have to be equivalent to what, say, the alleged promissory note or the mortgage note is.
Yes, I could have claimed the value of the bond should be set at 0 because plaintiff is not being prejudiced in this case because plaintiff is not the real party in interest.
Now, is that similar to like a Prevlin? Doesn't, like if you're doing, reprevlin, an action in reprevlin, is that you do also have to bond that?
Replevin action, yeah, I believe it has to be bonded too, yeah.
Yeah, okay. And isn't that when you're trying to acquire, I remember me and Harold talked about this months ago, and I'm going just off the cuff here, is where you're going back after your property, which would be the note?
Yes, and the court has to decide what's the action, and that has to be bonded. Yeah.
Okay. Now, do the courts normally look for the same value as say the promissory note was? Well, let's say the promissory note was only like $40,000.
Well, you'd have to prove that the value had dropped, or the value might have gone up. Maybe the plaintiff might prove,
Okay. Because in a lot.
Your county recorder, what its appraised value is, that's set up for the taxes.
Right. Because there's a lot of these, like even in these foreclosure actions, as you know, because the promissory note was put into general deposit and not special deposit, where they're keeping everything. They're keeping the property and the note.
People want to know why they're not getting their temporary restraining orders or their injunctions and things. It's because they probably haven't bonded the case properly. Because if you bond the case so that plaintiff is not going to be damaged, then what's the holdup from the judge not signing it?
Right, because there's no liability then. because it's offset by insurance.
Oh, the liability you've covered.
Right, it's offset by insurance.
Right.
I see. Well, let's say, for an example, you're going back on a foreclosure that happened 5 years ago. And, of course, now you're claiming special deposit, not general deposit, and you're going back in, and they've still kept your promissory note, even though they've kept both, the promissory note and the property. So you're going back in there with the indenture to saying, no, I want everything back, including my note, all the derivatives that came off the value, which was my signature. I'm claiming everything back, and I'm doing it under trust, in equity, in the private side of the court.
Yeah.
That's basically how we'd be doing it.
Right.
Okay. Now, once you get to the point where you have you've done your UCCs, you've done the indenture via a notary. Now the 10 days have passed, and you also have to allow 5 days mailing time. I also saw that in a federal rule that they do allow 5 days mailing time.
Right.
So it's actually 15 days using that hypothetical. So then the notary's sending the next letter saying, hey, you're in breach of trust right now because you have not responded back to me when I sent you this indenture.
Right.
So the notary has to basically notify the trustee, hey, you're in breach of trust.
Right. It's got to give them notice, yeah.
Okay, and then at that time it's done. Now it's just a matter of filing an action in equity to show and prove trust in chambers and that the other party is in breach. And when the other side attorney shows up, you basically slam him saying he can't talk at all because he has no beneficial interest in this matter whatsoever. And under the equity maximum, it can only be done in persona against John Doe from XYZ Bank. Since he didn't show up, here's my the breach of trust, and here is. Now, would you really be asking for injunctive relief at that time because the foreclosure has already happened?
Yeah, I'm going to have to ask for injunctive relief in the bill in equity.
Okay. The injunctive relief would be for the damages against you?
No, performance.
Okay, that's it. That was the word I was looking for.
Christian, I got a question about the bond, if you don't mind. You was talking about having the case bonded and the injunctions need to be bonded, but then we also know that the bond is the trust. So if we claim and prove trust, how does the bonding of a case play into a situation like that now, or the bonding of an injunction?
Well, you're going to have something colorable in their form processes and procedures they're going to recognize as a bond.
That's what I mean. So now when it comes to these public bonds, I should say, is it the same type of bond that these people are writing up and sending to Geithner and doing the debtor creditor way of writing bonds? Like, how would this type of a bond look?
A bond is just your signature, your promise. That's all bond is.
So as far as the public side of the court is concerned, do they have a form for you to just fill out and sign, and that would actually be bonding?
Along with the like the protective or the temporary restraining order and the other thing, the order that goes along with it, and the bond. I've given that out before.
So to understand this, just using that hypothetical, you're in chambers, you prove breach of trust, you're doing
Yeah, but that's the problem. Most people are not going to be in that specific scenario because they have not proved trust. They can't even get into chancery, into a court of equity in the camera. That's
let's just for this example, let's just say I'm there, I've proved breach of trust, now I'm ordering.
Yeah, but how do you prove breach of trust? Let's back up. It's not proving breach of trust. Can you prove there is a trust?
Yes. Here's a copy of the indenture. We're in chambers.
Most people can't.
I'm sorry?
Most people can't.
Okay. Well, let's talk about me. It's all about me right now. Okay, let's just say I'm in there. I'm showing the judge my indenture. They did not perform. That's breach of trust. I want injunctive relief, and the injunctive relief you're saying is from my signature, which is my bond. Would I have to bond that?
All right, what kind of injunctive relief are you asking for?
Well, once again, it's the performance to return trust res and all the derivatives of...
Okay, so that is, you want injunctive relief, and that was put in the pleading.
Right.
So now you're in chambers, you're asking for injunctive relief. You've already proved that there is a trust. The trust is in breach, and now you want performance.
Right.
Okay, now what?
This is what I'm trying to find out. The injunctive relief, would that have to be bonded or not? Because we're talking about
injunctive relief that was bonded. It was because I'm coming against the plaintiff in protecting his loss. But
right.
Now it's really my counterclaim now, and I'm in equity, and I'm acting as the plaintiff.
Correct.
He's got to bond me if he wants to do something.
I see. Okay. It falls back to them. All right. Okay. Understand that better. Okay. So we're going in there. We prove breach of trust. We have an injunctive relief. We have a bill in equity, and then at that point, do we also draw up the judge's order?
Yeah, you could draw up the order or have them write it up.
Now, would that be? Now, would the judge? Now, well, normally you would rather do it because judges are lazy. They don't like writing orders.
Yeah, well, I may have to have a little conference with him and ask him, just exactly what you want me to put in this.
Right. Now, and the thing is, would that order be a compelling of trustee performance? I mean, how would that order be kind of worded?
Yeah, I would probably be issuing some kind of mandamus on the private side there, and then a mandatory injunction on the public side.
Say that again. I want to be sure I got that right.
A mandamus ordering the court to issue a writ of mandatory injunction on the public side. So I got both private and public. I'm doing a mandamus order on the private for a public side mandatory injunction.
Okay. Mandatory injunction on the public.
We always got to think in a duality term. You got to be in control of both sides of the court.
Right, and that's why I'm trying to understand the form and procedure.
But the power comes out of the private side, and the private side is always by order, non-purgatory language, out of the private side from the real man, the grantor.
Order or decree, right?
Yeah.
Okay. Now, the term bond, doesn't that actually come from the term covenant in a sense?
Yeah, promise. That's a
because
trust.
Because it
can be a trust. Can be a trust. Let's put it that way.
Yeah, because normally, because like even with the word covenant, it's an exchange of something.
Covenant is indenture. It's a charter. It's a treaty.
Okay. All right.
It's anonymous.
Okay. That was just once again. I'm just I'm just kind of just shooting off the top. Once someone's in there, they of course they're in a public hearing first. They're saying, well, I'm only here to talk about breach of trust.
Yes, because if you argue the at-law side, you're dead.
Right.
You want to argue the fact that they're going to cancel your UCCs, you're arguing at law, and you're going to lose.
Right.
You need a counterclaim in there to get your motion on top and hear your equitable pleading, your bill in chancery first.
Right. It always has to be heard first before theirs is always heard.
Yes.
That's even on the public side. We know that. So I'm standing there in front of the judge saying, I'm only here to talk about breach of trust. That's the only reason why you're here. Well, I don't see a trust. Well, here basically are my witnesses, which is the state and the county. I can't discuss this any further, or else I would lose the privity of my private trust. The only place I can discuss this is in chambers. So I'd like to schedule an in-chambers hearing immediately or as soon as possible with you that we may discuss this and I could show you the private trust. He says, okay, let's go into chambers. We walk into chambers. I show him the indenture. He says, okay.
If he asks for it.
But don't you think chances are he's going to? And if so, shouldn't you be prepared?
Might not. I don't know.
I would think he would, especially if he's going to say, well, I don't see a trust.
Okay. Well, better count on it then.
Yeah, you know sometimes they're going to pull you to the rug to be sure you know what you know.
Yeah, well, that depends on each individual case, whether or not they think you know what you're doing.
Right. I'd rather be, I'd have a whole arsenal full of weapons right there than going in that courtroom naked. You know what I'm saying?
If plaintiff came at you and you do not have a counterclaim in there, you will not get into equity.
Right. So even on an existing at-law case, you want to come in on a counterclaim. Would it be a counterclaim or would it be a whole new suit?
Well, if plaintiff came at you and you didn't respond with a counterclaim, you're going to lose because you're not in equity.
Okay, but let's just say you lost at the at-law side. Let's just hypothetical, you lost at the at-law side.
All right, now you're coming at them in a new claim in an independent action, and now that is your plaintiff already.
Right, automatically, and that's my point. In other words, would I be the
plaintiff always gets heard first, and whatever is in his pleading is what is arguable, and that alone.
Right. So even if I'm coming, let's just say, for example, using this hypothetical, if I'm coming in a new action and he files a counterclaim, we got to hear his claim first.
Yes, it's easy. All you got to do, okay, if he's arguing something outside the pleading, just ask the judge, hey, we can't talk about that. Where's that in my pleading?
Okay. So if he's trying to bring in an at-law counter a motion, in other words, you're filing the original action. So you're doing it in equity, and he's filing a counter, which his has to be heard first.
Okay,
you're going to argue.
If you're in equity as plaintiff, I don't know if anybody else can put a counterclaim in.
Right, because the attorney doesn't have any first-hand knowledge, and he doesn't have a beneficial interest in that hearing.
Correct, and probably neither does the real plaintiff, because that's probably just a fiction also.
But he's got to be there to show up anyway, at least the CEO does.
Yeah.
So if he's not there, then he's already defaulted.
You won by default, yeah.
Right, because at the equity maximum, equity can only be performed in persona.
Yeah, but you got to get into equity because that's the different ball game, different rules.
Oh, absolutely.
Compared to 63 million statutes and codes on the other side. You'll never win in that other realm, even if you think you won.
Right, it's like the labyrinth. You never can get there. Understand? Right. Oh, okay. But that was my point. So even if anything is filed on the other side, the other party would have to show up in persona. The attorney can't do it, so you strike it down automatically that they're in default because it'd only be performed in persona.
They would have to have an equal, equitable claim to counter yours. Now, how could they?
Right.
Because breach trust on a performance.
Right, because they're going to argue at law even in a counter motion.
And in equity, you'll win hands down.
Right. But I'm trying to say, because in other words, if I was them, or what I anticipate what they would be doing, they would probably come in a counter motion, but it'd be an at law motion. So in other words, you
get rid of it.
Right. Strike it right down right off the bat. Let's just get into chambers and go from there.
Yes.
Okay. That's it. That's my question. So that's why I just wanted to see. So basically, is what we're saying, breach of trust.
That's what we were talking about here in the last 10 minutes. Do you think most people know this stuff?
I don't know.
Ask the concepts here.
Quite frankly, Christian, I'm, it's just like each one of us. We study at our own pace regarding what our daily functions allow us to, and we try to digest as much as we can, and that's going to be based on typically our performance. It's a reap and sow. What you put in is what you get out.
Good analogy. What you put in is what you get out.
Right, and the thing is, I'm even myself. I wish I could dedicate so much more time to this, but unfortunately, what I do even during the day when I am working on other things, I listen to the recordings repeatedly. Then it just brings a new light because I'm seeing everything in special, to do things special and to get away from that general side, which is the killer. And really, that's where you lose all your rights, is on that general side. You get into special, now it's a whole different ball game. Now we're talking right, interest, and title. It's whole different compared to the other side.
Right, right. What you sow, you reap. What you invest in is what you get out.
That's
Same
right.
thing.
Yep. Reap and sow. Okay, that's my only question. Thanks a lot. And I'll probably touch base on this once again. But that gives me the forum. That gives me the format. Once we get in there, what we need to do. And they still have to go by the same thing: records, procedure, same exact thing. Even what they do on the public side, same thing on the private side. But there still has to be in an orderly fashion that they also too have to recognize, even though it's in the private.
Right. So let's take one more caller. Yes.
Okay. Thanks.
Who's next? Jeff, you're unmuted.
Hey, good evening, Christian. Can you hear me?
Yes. Go ahead.
Excellent. Hey, okay, I posted some stuff about mandamus and injunctions on the Skype page. I can read some of it to you because they go into a administrative remedy for a mandamus. You have to do exhaust. Let me read it to you. Mandamus is an extraordinary remedy available only when all three of the following conditions are met. The petitioner has a clear legal right to the relief sought. The respondent has a ministerial duty to perform the requested act without discretion to refuse. Sounds like trustee. And the petitioner has no adequate remedy at law.
Yep.
So the ministerial duty is one that is to be performed by an official in a prescribed manner based on a particular set of facts without regard to or the exercise of his own judgment upon the property of the act being done.
Yeah. If you get into chambers, you get the mandamus in there, and that judge is, against that trustee, and he's going to force them to do the performance. He's got to do the performance. If he doesn't do the performance, then his case is dead.
Yeah, but also it says here, in general, movement must exhaust administrative remedies before seeking a mandamus. So we have to have, a default, basically, of two or three step process.
Of a breach of trust is.
Yeah, but that's a private document.
Yeah, it is. It's a private document. Yeah.
Yeah, but what would represent that breach document in the public?
Say that again.
What would represent that breach? What would be a colorable way to represent a breach in the public?
Why would I want to bring it in the public?
Well, if they're saying you have to exhaust your administrative remedies,
all I do is show it to the judge in chambers.
Okay, I got it. I was just so is there no colorable way to represent a breach of trust in the public besides just put it on a public pleading? I guess that's it.
Give a public.
Yeah.
And what's a public notice of a breach of trust? Well, there's a constructive notice of a RA number such and such held in the private, blah, 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 and that's it.
Yeah.
You want more details on this? Call the grantor. In other words, you didn't waive the privateness of the notice. You just gave notice that something happened, but you don't know what it is. Now, give a verbal public notice. It didn't reveal any private nature of the breach of a private trust.
Right.
I didn't commingle. I didn't breach trust myself.
Yeah. So actually, that brings up a question. The whole idea of having a unique identifier number, like the registered number, to identify a claim. Now, if you say you posted a public notice of that number and you wanted to include the court case to tie it in, would that be commingling by putting that court case number in that unique identifying number? Do you know what I'm saying?
Case number and the RA number?
Yeah, just when you put a claim out there in the public.
So you're taking the RA number combining with the case number?
Yeah.
Doesn't that form a whole new unique number that doesn't represent anything?
Well, it represents what I want it to.
Yeah, right. It's your intent.
Yes. So that way it's then it's even more correlated in a way. Does that make sense?
What you understand, yes. But it doesn't nail anything down specifically.
No, but it just kind of identifies my claim that much more specifically.
Yeah, it would. Why would I want to do that, though, really?
Well, I guess because the whole idea is, can they rebut it? They can't. Do you know what I'm saying?
Rebut the case?
Rebut the claim. Because that's, I guess, what it comes down to is the claim, right? Whose claim is on top, essentially? Well, I'm the grantor. You're the trustee. I've got evidence and records here to prove you're the trustee. Can you rebut this? Otherwise, it stands.
Yeah, well, but the number recorded in the county really doesn't have to be there, but.
Yeah. Okay. It's just like, claiming the case and tying the number to it by sending them res, once they have the.
I like to keep things as private as I can. I'm not going to give any more public notice than that case number's already been publicly made noticed. Why should I spread it around some more?
Yeah, I guess because I'm claiming it. I'm identifying it as I'm claiming it. I'm putting it inclusive in my claim. Does that make sense?
Yeah, while you're walking along the cliff, I really want to stay as far away from the edge as possible. That's really.
I got it.
Some people like to walk on the edge.
Yeah.
I like to look down. But, hey, there may be some slippery rocks ahead. The ledge may give away, and if it does, where am I?
Right.
I like to be back in a safe distance.
Yeah. Hey, I have one other question about the injunctive relief also. Say hypothetically someone was going to put an injunction against you. Now, if they didn't have a bond, that would be an invalid injunction. Is that correct?
Yeah, probably they would never have gotten an injunction if it didn't have a bond.
Oh, the judge won't even issue it if the bond's not there.
I don't believe so.
Now, what if I wonder, is that bond public knowledge?
They don't tell you that, but that's probably why most people don't get their TROs. They left out some elements to support the TRO action, or else they didn't bond it.
Yeah, here's some preliminary injunction stuff. 3 points or 4 points. When deciding whether to grant a preliminary injunction, this court must determine whether the moving party established a reasonable likelihood of success on the merits, whether the moving party will suffer irreparable harm without the requested injunctive relief, whether the balance of the equities, including the public interest, weighed in favor of the moving party, and whether the issuance of a preliminary injunction served to preserve the status quo ante.
Yeah.
That make sense?
Yeah.
Okay. Well, it's kind of interesting. So is that bond public knowledge then? If you have an injunction, that bond should be available to the public to see?
A lot of background noise, scratchiness. What was that again?
Oh, I said, if you've got an injunctive relief in the public, then is that bond viewable? You should be able to view that bond in the case publicly?
Yes.
It should be part of the case.
Yes.
It should be in the case file, the bond.
The public side, yes.
Yeah, got it. Interesting.
That's their process, that's their procedure. Should be there.
If the bond's not there, then that injunction is invalid.
Probably. I don't see how it could get issued, but if it did get issued without a bond, you could probably attack it right there.
Challenge it on the bonds.
Yeah.
That seems like a really simple.
Yeah, but usually they will not have a ex parte temporary restraining order issued against anybody because they always want the other party in there to make counter challenges.
Yeah, they want to fight. They want to fight and argue.
Well, it's really not fair to the other party if you want to look at it.
Yeah, ex parte hearings don't seem very fair to me at all, but I don't know. I guess it's just part of the procedure.
That's why they only do it in very rare cases under, irreparable harm and damage that is causing a unique problem.
Yeah. Okay, well, thanks so much, Christian. I posted a bunch of that stuff on the page if people want to take a look at it.
All right.
Okay, have a good night.
Okay, thanks, Jeff.
Mm-hmm.
So any of the TAs want to have any closing statements? Eric, you got anything?
No, I'm good. That was a great conversation tonight. Thanks for giving me the opportunity.
Anybody else? Marshall, Mike, anybody? Floyd?
Oh, I concur. It was great info.
Right. I agree.
And Christian, I know you want us to do the bill in equity, but I felt like it was appropriate for us to lay down some of the foundations so people understand how to CJS and maybe some of the things we want to put into our bill so they'll have some ideas. So hopefully next week we can actually get more into the construction of it, the actual construction.
We will.
Right. That and a motion for our motion, mandatory, excuse me.
Memorandum of law and equity, yes.
Yeah. Well, I would call it, instead of memorandum in law, I would call it memorandum in equity.
Yeah, that's what I meant to say. That kind of the law part kind of slipped out.
Or special memorandum in equity.
Well, I can go to the law library and start looking through the reinstatement first. Start getting some of that together.
Let's see. Where was I looking? Let's see. A good place to start is in Gilbert.
Gilbert's?
Yeah.
Yeah, it does have a lot of references from out of there. You're absolutely right.
Okay. Well, everybody, we'll call it a night. So, see everybody tomorrow night at 10 p.m.
All right.
Everybody have a great evening. Good night.
Good night, everybody.